record?
Call the meeting to order.
This is the meeting of the Sunshine Ordinance Task Force for March 1st, 2017 at the hour of 4 p.m. On the call of the roll, Member Baranetsky, absent. Member Eldon.
Present.
Eldon present. Member Josh Wolf. Wolf absent. Copra absent. Member Tesla.
Present.
Tesla present. Member Moss.
Present.
Moss present. Member Kanata.
Present.
Kanata present. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Highland absent. Chair Wolf.
Present.
Wolf present. We have a quorum. There are no agenda changes that I know of at this time.
On my report, the item that I continued for the research on the ordinance, I want to, let's continue that to the next meeting. I'm not done with my research on that. Any other changes? Adjustments? Moving things around? Nothing? Okay. Let's we approve the agenda by acclamation. Seeing no objection. Any public comment on the agenda?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I've beaten this drum before, but I'm going to beat it again. Here we are with the minutes from the last meeting, and there were 4 members absent. Here we are again with 4 members absent. And I keep raising the issue that if 4 members are absent, that's 4 no votes against the complainant, which means they have to get 6 out of 7 votes to have a finding. And I don't know about anybody else in the public, but I'm getting a little tired of coming here and getting 5 or 6 votes and then having it fail because 4 people aren't here. The mayor's policy is that if you can't come to the meetings, then that should be reported to the mayor's office, and after a certain number of missing meetings, you're out. It is not fair to the public to expect them to get a supermajority of the votes to prevail. That basically just throws it completely on the side of the respondents, which is the city. Gee, as long as we can get 1 or 2 people to vote no, well, we can win. They have to get 2 votes. We have to get 6. So I have to ask you, is there an intention by this body to do anything, or is it simply going to go on for years, as it has already gone on for years, where members sign up for this commission, this task force, don't show up, and nothing happens? And I'll point you to the Rules Committee where they were hearing Judge Kopp's request to be reappointed to a full term to the Ethics Commission, and the only question that Norman Yee, Supervisor Yee, had for all of the people that were being appointed that day for other commissions was, what's your attendance record? And he said, you know, I'm getting complaints about this. He says, I'm having people call me up and saying that there are people that are getting on these task force and on these boards and commissions not showing up for the meetings. And my question is, if you're not going to come to the meetings, why are you putting in for it? Is it just to have something to gloss your resume or whatever it happens to be? It's not acceptable. And you can all look down at your papers and avoid looking at me or listening to what I'm saying, but that doesn't change the fact that it is totally unreasonable. How many of you would like to be before a board or commission and know that you had to get 87% of the vote to win and your opponent only had to get 13% to defeat you? I don't think you'd be very happy with it, and I think you'd be saying something about it. And believe me, I've lost several cases because of that.
Thank you. Any other public comment on the agenda? Seeing none, we'll take this by acclamation. Seeing no objection. Okay, call the next item, please.
Next on the agenda, item number 2, approval of minutes from the Sunshine Ordinance Task Force February 1st, 2017 meeting.
Any changes to the minutes? Or a motion to approve the minutes?
So moved.
Second.
Moved by Member Tesfaye, second by Member Kanata. Any comments, changes, adjustments, public comment on the minutes? Seeing no public comment on the minutes, can we take this by acclamation? Seeing no objection, item is passed. Next item, please.
Next on the agenda is item number 3, file number 16115, hearing, Annual Supervisors of Records Report.
Okay. Please come forward. Thank you. Please state your name for the record.
Good afternoon, Commissioners. Brad Russi from the City Attorney's Office. I'll just say a few words and then attempt to answer any questions you may have. As you know, the City Attorney serves as the Supervisor of Records under the Sunshine Ordinance. Various attorneys in our office attend to this function. You have before you two reports, the report for 2015 and 2016. In 2015, we received 11 petitions. 4 of them we were able to work out a resolution to. We issued determinations in 5, and 2 of them are outside the scope of the duties of the Supervisor of Records. In 2016, we received 18 petitions. 13 of them we were able to reach a resolution for the petitioner. We issued 4 determinations, and 1 was outside the jurisdiction of the Supervisor of Records. I'm happy to take any questions.
Members? I have a question. So when you say that you're facilitating, are you actually helping complainants or requesters get their documents or whatever they're asking for?
Typically, when we receive a petition, assuming that it's an issue that we can address under the ordinance, we'll contact the department and to find out what actually happened with the petition. As you know, many times departments may not have responded at all, or they may be not have been clear in the exemption that they've relied on, and we'll try to work with the department to figure out whether they've completely responded and whether there's a basis for their response.
And do you find that there are respondents that are recalcitrant or that are not responsive to your call?
I haven't experienced that, no.
Okay, great, thank you. Anybody else? Okay. Recognizing Member Vice Chair Hyland walk in. This is the report from the Supervisor of Records. If you have any questions before I close it. Okay. Thank you very much. We
Thank you so
appreciate
much.
it. Thank you. Okay, next. Oh, I'm sorry. Public comment.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I have a couple questions. One is why you're getting 2 reports for 2 years when it's supposed to be an annual report and it's supposed to be here annually. The second is, I think the cursory question about, did you help the person get the documents was really not answered. And I know from my own experience, I have a finding of violation against Deputy City Attorney Paula Jessen because after 2 petitions to the Supervisor of Records regarding matters that I was trying to get from the library, which they responded over a period of 2 years, and both of those petitions were denied. And it's like, okay, so they've had a year and they haven't responded, and you're denying the petition because they're working on it, which is basically what the answer was from the city attorney's office. And then after the second year, I put in a second petition to the city attorney's office, and DCA Jessen again denied the petition. And I'll be honest with you, I've read the thing a dozen times, and it never made any sense to me at all. If you have a city department who is dragging out a response for 2 years, they're clearly in violation of the law. And if they're not responding, It is the responsibility of the city attorney's office, in particular the deputy city attorney who is supposed to be dealing with the matters of record, to direct them to disclose those records. And very frankly, I don't know what the problem was. I kind of got the feeling the deputy city attorney, Jessen, didn't think that if she told them to give the records that they would listen to her either. So you're kind of in the same boat. If the deputy city attorney calls up a city body and says, we've got a public records request, you've got an order of determination against this the body or the institution already, and you're still not responding, and then turns around and denies the petition, and the body, the person who is being asked for the records continues to dribble those out for 2 years, there's something wrong. Something is rotten in the state of Denmark, as Shakespeare would say. So I have a real question as to whether or not the city attorney's office really has placed a good faith effort in these matters, and whether or not they have and are willing to use the necessary force that their office holds to compel bodies that are supposed to be following this law and have been supposed to have been following it since 1999, I think that's the correct year, to put up or shut up.
Is there any more public comment? Seeing none, okay, we'll close this hearing and move on to the next item.
Next on the agenda is item number 4, file number 16027, complaint filed by Charles Pitts against Kenneth Reggio and the Episcopal Community Services for allegedly violating Administrative Code, Section 12L.5 and 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, let's hear from the complaint committee that heard this item.
So when we heard this item, we did not have the petitioner present, but we did hear from the representative of Episcopal Community Services. In this case, Mr. Reggio, who was the representative from Episcopal Community Services, argued that the Sunshine Ordinance did not cover that organization as a nonprofit. Mr. Pitts had been requesting certain information about his time through their navigation center. Some of the discussion between the complaint committee members, we were discussing the applicability of Administrative Code 12L, which does govern nonprofit agencies. Here we did not find that it was applicable because Mr. Pitts, the petitioner, had put the request into the agency, not to the nonprofit, rather than to the nonprofit agency that was the holder of the records. So in this case,
You mean the other way around?
Excuse me, yes,
Yeah.
the other way around. And so the finding from the recommendation from the complaint committee was that the task force did not have jurisdiction over the complaint. Outside of that, it seems like Mr. Pitts, from some of the correspondence that was in the file, has received the documents that he needed. But here we're still looking. But there could have still possibly been a violation should there have been jurisdiction found over this agency. So that's where we are. The committee doesn't think that there's jurisdiction.
Okay.
Under the Sunshine Ordinance.
I would like to mention that Mr. Pitts did send an email requesting an indefinite postponement, but I believe that that is an issue that the task force has concerns with.
Indefinite postponement means to
What does
kind
that
of kill
mean?
it. You know, that basically would kill the whole thing anyway. I think if we find that it's not in jurisdiction, then we won't hear the case.
Right.
It was a processing error, I think, on Mr. Pitts's part, or the petitioner's part. So why don't we do that officially? Let's get a motion on the floor to find jurisdiction or not to find jurisdiction, and do it that way.
Motion to not find jurisdiction.
Second.
Moved by Vice Chair Highland, second by Member Hinsey. I'm just wondering if maybe we should just do it in the positive and just fail it. Do we find and violate? Sorry?
That works too.
Yeah, I think just as a matter of consistency, we always find and violate, do we find in jurisdiction? And then if the motion fails, then it's not found in jurisdiction. Because the expectation is that it would be found in jurisdiction.
Do I need to rephrase
Yeah.
the motion?
Yeah.
Okay. Motion to find jurisdiction.
Seconder agrees.
Okay, same mover, same seconder. Any comments? Yes.
But doesn't that mean the motioner and the seconder need to vote for jurisdiction?
No, we
No.
vote no. We vote no because he,
It's just a motion on the floor. We can vote either way.
Take the,
So you could vote against your own motion, though? I thought that
You
was...
could always do that. Yeah.
we
That's what I would
can,
do.
well, generally because we want something on the record. So how would you, so it wouldn't be reflected. We want at least to always have the body give the benefit of the public to make a decision rather than have an empty space in the minutes that there's, yes.
In the past, and actually this was Rick Nee who instituted this a long time ago when he was chair, and he even wrote up in his little notes to us, if there's no motion, then there's no motion, and he thought he's presented it better than I ever could, something about it is specious and fallacious to, have a motion when there is no need to, and it's just a time waster, and that's the path that we took, or at least I took when I was vice chair and chair.
Okay. It doesn't take much to do it. I mean, if you do get public comment that may have some bearing on the issue, it may be helpful also. So, but I think as far as the Roberts rules is concerned, I think Member Wolf is correct that the makers of motions cannot vote necessarily against their own motion. So I think we should revert it back to, I think you're correct, and I'll hold that to be correct at this point.
Through the chair?
Yeah.
If we, could it not just go in the records that you could ask, is there a motion for jurisdiction? Seeing none, the task force found no jurisdiction. There was no motion for jurisdiction, period, and that's what goes in the minutes. That's the clearest way.
I understand that, but the purpose is whether, the question is do we find jurisdiction or not? And I think that always should be put before the body. I don't think it should be, I think it's a lack of due diligence not to do that because it puts some finality on it. Okay, and I think it reads better in when people are reading the minutes than to leave it out in the question like what happened? Why didn't they make a motion at all?
Well, I think then, just to answer, maybe my original motion is clear
Yeah.
because it's showing that there's an irregularity here.
Yeah, I would agree.
Rather than the reader would be wondering, well, why didn't the motion pass?
I agree.
So I'm going to restate my original motion to not find jurisdiction in this case as it's not appropriate. You can have that as a full motion.
Okay, same mover, same seconder, Member Wolf.
I mean, I think what addresses your concerns is to call it to find no jurisdiction instead of to not find jurisdiction.
Yeah, to find
Stronger motion.
no jurisdiction.
Right.
Correct. Okay. Got that?
Yes.
Okay, public
Motion is
comment.
to find no jurisdiction.
Public comment on the motion to find no jurisdiction. Seeing none, can we take this by acclamation? Seeing no objections, the item passes. Please call the next item.
Next on agenda. Sorry. Item number 5, file number 16028, complaint filed by Charles Pitts against Sam Dodge and the Human Services Agency for allegedly violating Administrative Code Section 67.25 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, go ahead.
So this item is actually related to the item that we just heard. In this case, Mr. Pitts put in a request for the documents related to his time at the Navigation Center to the Human Services Agency. And he did not receive the actual documents from Mr. Dodge, who was the respondent from the Human Services Agency, but he did receive a response on time where Mr. Dodge directed him to Episcopal Services, which was the agency that I referred you to earlier. So, and the recommendation from the complaint committee here was not to find a violation because he did receive a timely response. The response did not include the documentations about his time from the Navigation Center, but it did direct him to the nonprofit agency that was the holder of those records.
Okay, so is this in jurisdiction? Are you recommending?
We recommended that we did have jurisdiction over this matter, but that there was no violation.
Okay, let's deal with the jurisdiction part first.
Sure.
And then we can deal with the no violation. Okay, need a motion for jurisdiction?
Motion to find jurisdiction.
Moved by Member Hinsey.
Seconded.
Second by Member Moss. Any other discussion? Public comment on jurisdiction? Seeing none, can we take this by acclamation? Seeing no objection, item has passed. Okay, is there anything you want to add with regards to the merits
sure.
of the case?
So Mr. Pitts had put in a request in February 24th, I believe, an IDR for the documents about his time at the Navigation Center. He received a response from the Human Services Agency on the 25th, letting him know that Episcopal Community Services would be those that held the documents, that they didn't have any records about his time through the Navigation Center, and they did direct him to the appropriate entity to try and get his records. So we recommended that there would be no violation because there was a timely response to the IDR, as well as giving him the information for the agencies that they were assisting him with as much as they could to get those records.
Okay, great. All right, let's move to the hearing. Is the petitioner complainant here? Okay, seeing, are there any witnesses or persons on behalf of the petitioner or complainant that can provide any facts or evidence? Seeing none, is the respondent here? Okay.
My name is Matt Brown, B-R-A-U-N. I'm here representing HSA. Diana Christensen, who replied to Mr. Pitts's request, is no longer employed by HSA, nor is Sam Dodge, who he registered the complaint against. But Mr. Pitts's request was received by Trent Royer on the, bear with me one second, on the 24th, and Diana Christensen, the custodian of records for HSA, replied on February 25th, 2016, in full.
Okay. Is that it?
What else can I tell you?
Well, if this is your time to just tell us the story, and we'll ask questions.
The story precedes my arrival at HSA, and was a time where the people involved are no longer at the agency. So I've pieced it together as best I can. But essentially, Mr. Pitts was looking for records held by the Episcopal Community Services, not HSA. Our response directed him to Episcopal Community Services.
Okay.
And that was about it.
Okay. Thank you very much. Sure.
Thanks.
Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, seeing none. Members? Vice Chair Hyland.
Through the chair, I'm just wondering, we're tackling a lot of these cases at the committee level. I'm just curious, with your experience, maybe others here, could that committee have perhaps acted more strongly on this case, in that it appears to be black and white, and that it was satisfied, the requester was helped, directed to the right place, case closed? Would this even need to be in front of us? I'm just throwing that out there.
The task force is tasked with making the final determinations.
Okay, so the committee can't make that, can't table it, can't...
They can only make a recommendation.
All right.
Because the ordinance doesn't even speak of committees.
Or continue it, which we're trying to do more of if we don't have the facts.
Yeah, or they can continue. Right, exactly.
All right.
Okay.
Do we need to spend more time on this?
No, we do not.
Motion
Go ahead.
I guess motion to find no violation.
Second.
A move by Vice Chair Hyland, second by Member Hensy. Is there any public comment on the motion to find no violation?
Ray Harsh, Director, San Francisco Open Government. I'm kind of questioning the logic here. The first item was him asking the Episcopal Services for the records. The second is asking the HSA for the records. And the HSA is saying going to Episcopal Services. So we'll say Episcopal Services is not in violation because he didn't give him what he asked for, but we're not going to find them in violation for sending him to the people who refused to give him what he asked for. It really is very similar to what I experienced when I asked the library for information about what it was costing to have a deputy city attorney at library commission meetings and a San Francisco police officer at library commissions, and they simply said, well, go ask the police department and go ask the other people, which is basically, and you found them in violation because all they had to do was go to those two bodies and ask them, would you please give this person the information? And I think saying that the limit of the responsibility of a department is to simply say, well, go ask somebody else is kind of counterproductive. I think they have a responsibility to, call somebody up at HSA or at the Episcopal Services and say, we had a public records request. Can you help this person get the records? Because otherwise, people like Mr. Pitts are just going to be shuffled from pillar to post and get no access to the records. And I think that's unconscionable given that Episcopal Community Services, I believe, gets money from the city to operate the facility these records are involving. And as a result, I think has an obligation to answer or at least assist members of the public who are raising questions about their operation and if that operation is paid for in part with city funds. I think it goes a little beyond just saying, well, go ask them.
Want to clarify?
Before we take a vote, I would like to clarify.
More public comment, I think.
Oh, more public comment. Okay.
Go ahead.
Gentleman wants to.
Good afternoon. Ken Reggio, Episcopal Community Services. So if I can speak to the issue on this, I fully agree with the gentleman. If Mr. Pitts were being stonewalled, that would not be a good way to go on it. In fact, ECS complies fully with Section 12L, which is applicable to nonprofits on disclosure of public records. But beyond that, outside the jurisdiction of 67.25, because we are not a city office, notwithstanding, we provide our clients, our residents, with any request that comes to us for their own records. So in the case of Mr. Pitts, his records were supplied to him. They were not supplied by 5 o'clock the following day. We don't have the capacity to do that. I think that's a bound, and that's part of 67.25. That's not part of 12L. Requests for client records are not part of 12L. But despite that, we believe best practice is to provide records to people that request them when it is involving themselves. So within a week, I have the dates. I don't think you need that for this hearing, but within a week, we provided Mr. Pitts with the records that he requested. They did get waylaid in the mail. There's a reason for that. He ended up having them in his possession within about 2 weeks of the request, 2.5 weeks of the request. He then requested a grievance hearing, which we gave him as well, and we complied with our commitments within that grievance hearing. So I guess I'd just like to make the record clear that there was no stonewalling on our part. In my opinion, which is probably irrelevant in this, I think the department acted appropriately as well by referring Mr. Pitts to us.
Thank you. Any other public comment? Oh, Member Moss.
Could I ask Mr. Reggio a question?
Sure.
Yeah. So I just want to make sure I understand. So when you have a client, do you ever transmit any records related to that person to HSA?
I'm inclined to say no. I'm trying to think if there's an exception on that. They're subject to examination by HSA, so we have regular monitoring on all of our contracts. We're a major provider of services to homeless people in the city. So HSA, actually the new department now, DHSH, which has taken on the contracts regarding homelessness, monitors regularly any client files. They're examined randomly, so they have access to it. We do not forward client files to HSA. We are the keeper of the files, and we keep those confidentially, locked, and disclose them to no one short of a subpoena or short of a client's request for his or her own records. And in that case, we redact them to take out the names of other clients. So if there was an engagement, let's say, or a conflict with another client, if that's in behavioral health notes, that would be redacted, but the client would have full access to anything that regards himself or herself.
Okay, thank you.
Okay, thank you.
Thanks.
Okay. You want to clarify?
I'm glad that Mr. Reggio is here to do the clarification because, as I mentioned, when we looked at the first matter, we were only talking about a potential violation for timeliness, and then we did not find jurisdiction because we knew that Mr. Pitts had received the records. He had contacted Victor, and there's that communication in the file that he wanted to maybe keep the file open indefinitely, but we had already stated that he had received the records, so we were only potentially looking at timeliness, and then we found no jurisdiction, and that's why we're on the second item that tells the rest of the story.
Okay, great. Just as a note on 12L, the process for 12L specifically is that a requester of information goes to the contracting agency of the nonprofit. Contracting agency will then actually do diligence to get the information and transmit that to the requester. And if it is unsatisfactory to the requester at that point, then it comes here, and then the agency is brought forward. The agency, most of the time, will also bring somebody from the nonprofit organization to answer questions as to why or why not they wouldn't do it. So that's just the basic process for 12L. Okay. Motion.
We have a motion on the table already.
Oh, we do. Okay. And that's the end of public comment. Let's go for a roll call.
On the
Could
motion,
you restate the motion?
the motion is find that the Human Services Agency did not violate Administrative Code Section 67.25 in relation to timely and in terms of responding to a media disclosure request in a timely and complete manner.
Yeah, no violation.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Great. Okay, next item, please.
We are going to temporarily skip over public comment at this time, as it's not yet 5 o'clock.
It's a first.
Item number 7, file number 16119, complaint filed by Ellen Sang against Director John Ram and the Planning Department for allegedly violating Administrative Code Section 67.21, 67.24, 67.25, 67.26 by failing to respond to immediate disclosure requests in a timely and/or complete manner. On January 24, 2017, the Complaint Committee reviewed the complaint and referred it to the task force with the recommendation to find jurisdiction and find that a violation of Administrative Code Section 67.21 and 67.25 occurred by failing to respond to immediate disclosure requests in a timely manner.
Okay, I have a motion for jurisdiction.
So moved.
Second.
Moved by Member Kanata, second by Member Fisher. Is there anything from the Complaint Committee on jurisdiction?
We recommended that jurisdiction be found on this item because this was a matter dealing with the city's planning department and specifically for records that they have regarding a specific property. And we make the recommendation that we find jurisdiction.
Okay, great. Any public comment on jurisdiction? Seeing no public comment, can we take this by acclamation? Seeing no objection, item is approved. Okay.
Some of you might remember this case. We were able to hear from Ms. Singh at the last meeting, and we wanted to do a continuation so that we could give an opportunity for the parties to put some more facts together and make for a more robust case. As a reminder, Ms. Singh was looking for specific copies of documents related to 2650 Hyde Street, as well as references to specific pages of relating to this to this property from the planning department. It appears that some of the documents might not be in the planning department's possession, but they never communicated that to Ms. Singh. We're hoping that today Ms. Singh will be able to provide us with an answer that the planning department followed up with her and was able to provide the actual sources of their planning department determination on this specific property. But at the time, it was that they had provided some preliminary documents, but not the full reference documents that she had requested on 2650 Hyde.
Was this, through the chair, was this the blank checklist case? I'm remembering.
No, that was a different person.
Okay.
I believe if you reference
That was anonymous.
page 377, the planning department provided the response or statement on that page.
Okay, thank you.
Okay, great. Let's hear from Ms. Sang, petitioner.
Okay. First, I want to thank you for your time and effort in trying to help the public to receive a response from planning. Planning has claimed that they previously provided docket ABC, total 438 pages for the previous request. Therefore, they state that I should review each of my current 9 requests, then review 439 pages 9 times to choose the word of the page I think that I should guess are their responsive record to my request. It has been planning's practice to dump several hundred pages to the requester and ask them, you choose what you want. You requested planning to provide reference specific pages that related to each of my requests. From the 438 pages, planning now admit that there's only 2 pages are related to my request. First page is page 52 from docket C to my request number 2, and then they claim that that's for the permit application number 2005-0927-4018, and the applicant is Robert Middlestaff. The second document is from page 1 of docket B in response to my requests 6 and 7. 6, they says that the DR number, his discretion review number is 2006-0396D. Number 7, they says this docket is referred to the permit number 2006-0110-1829. But the docket is showing that it's for the permit number 2006-0110-18, not 2006-0118-5315. Now they claim that it's for that. So planning should explain that why they use a completely different permit number 26-2006-0118-5315, which is not shown on the DR file. They claim that it's the response to my 7. I request the record from a memorandum issued by planner Sarah Velvet, who has a personal knowledge of my request and is still working for planning, but planning has prevented her to respond to my request, rather assigned the planner Andrew Perry to respond. Andrew Perry has no personal knowledge because he was not even working for planning at the time the planner Velvet issued the memorandum. Planner Perry created his response without any planning record, and then document by giving his opinion and guesses. Planner Perry responded to number 3, said withdraw the permit number 2005 was requested by project sponsor. And at the same day, planner Sarah Velvet sent back the permit to the building department. And Planner Velvet has the personality and the related document, like memo, note, email between herself and the permit applicant or sponsor and others when the permit applicant request for cancellation, because the permit in the planning, not in the building, the request cancellation is made to the planner, not to the building. That's for sure, the DR file always remained in the planning, not building, because the building has nothing to do with the planning issue and would not keep the planning record for planning. Now, the planning claimed that except 2 pages document, they have no other record for all my other requests from planner Velvet's memorandum. I ask you to order planning to produce those records that the planner Velvet has, including her email, that's related to my request. Thank you.
Okay. Is that it?
Yes.
Okay. Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, complainant? Seeing none, the respondent, planning.
Good afternoon, Chair and members of the task force. Christine Silva, planning staff. On Thursday, December 22nd, the Planning Department received an immediate disclosure request from the complainant, Ellen Singh. Ms. Singh's email requested information related to a project at 2650 Hyde Street, and in her email, she requests 9 separate items. On Tuesday, December 27th, planning staff Andrew Perry responded to Ms. Singh's email, clarifying and providing answers to the 9 items while also indicating which records already in her possession would contain the information she sought. Let's see. The department acknowledges that we failed to respond to the immediate disclosure request before close of business the next business day. Instead, we were able to respond and complete her request the following business day, which due to the Christmas holiday was Tuesday, December 27th. On January 24th, the complaint committee requested planning staff reference specific pages from the discretionary review docket that responds to each of Ms. Singh's questions submitted on December 21st, or provide statements in writing if no records if planning does not possess the responsive records in that case docket. On February 22nd, we issued that memo and shared it with the complainant, and at this time, all relevant documents have been provided to the requester. I will note that Ms. Singh is correct. Of the 9 items, item number 7, where we identified the permit number from page 1 of the PDF labeled docket B, the number is incorrect in the memo. It's a typo. The actual number is on page 386 of your case packet, about 3/4 of the way down the page, which is the 2006 number here. That completes our response. Happy to answer any questions.
Okay, thank you. Maybe in a moment. Any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none. Members. Go ahead. Member Tessa.
Ms. Silva, can you approach the microphone? On page 386, there was a typo. What's the number that's incorrect?
So the inquiry was asking for the building permit application number that was in which the DR was filed against. That number is 2006.01.10.1829. And on my memo,
we're on page 386 of the packet, correct?
Correct, yep.
Okay, and so you said it says 2006.01.10.1829?
Correct.
And it should be the other number?
It should be this number.
Okay.
On the memo, it's incorrect.
Okay, and then can you go to page 359 of the packet?
359.
Which it just has the 9 questions. It's in several places on the packet.
Yep.
So for all of those items, you said that you have sent responses. Was the response for any of those items that you had no documents?
Yes, and that's in the memo on page 377.
And which ones were the which were the numbers that you have no documents?
We were able to respond to numbers 2.
No, which ones do you not have any documents?
Oh, okay. 1, 3, 4, 5, 8, and 9.
Okay. Can I ask you a question about item number 8, the date and time the new transfer DR public hearing was held?
Correct.
Why don't you have the date for that? I mean, the information for that number.
So our records don't indicate that a hearing was held.
Okay.
The applicant withdrew the building permit, and so the hearing never happened.
Okay. Those are all of my questions at this time.
Okay. Anything else?
Those are all of my questions
Okay.
at this time.
Members, anything else?
Ms. Tseng, good question for you.
Vice Chair Harlan.
So it looks like they've addressed those 9 items. They've been responsive to 3, even though they misquoted the number on the memo. They actually gave you the correct material. Is that correct so far?
Yeah, they provided 2 documents related to number 2 and
7 and 8.
6. Yes, I know that you don't care why I asking. I paid a couple $100 for the DR report. The DR report was never heard. I never notified that whatever happened. Now my money is gone, and I wanted to know what happened. City have my money, and for particular purpose.
Sorry,
for
what's the DR report?
Discretionary review report. Okay. And now we want to know, I want to know where's my money, what happened. Now they says the transfer this and transfer this. There seems no record. The planner itself, Sarah, has email, have all those things. You just cannot tell me all of a sudden everything's canceled, but no record at all. There's something she has email at least, I know.
So what you're saying is even though the permit was withdrawn, you think there should be documents responsive
the planning, because the issue from the planning, the planner should not be that lazy. At least ask the planner to respond, because she issued that memorandum. Not just I created those questions from nowhere. It's actually direct quote from her own memorandum, and then she has to have some kind of record to create those memorandum with the city's letterhead and stamp. You cannot say that take my money and issue the memorandum. Now I cannot tell you anything. I just have 2 pages for you. This is just, I think this. Maybe the planning is so rich they don't care about the few $100 I pay, but I do.
Okay.
So I think that I'm sorry. I still think that the planner issued the memorandum. Do you have the record? At least minimum, her note and says somebody requests a request. Unless she said I requested cancellation, that's different. But she did not say that.
And you're talking about Sarah Velvey?
Yes.
Okay.
And then she never show up, and then they prevent her to answer any question. Aside somebody don't know. He was still a student at that time.
Okay. And you're saying that at one point you did receive some memorandums from her?
Oh, yes. I provided to you. They did not, but I provided to you. Yes, I did not. The question I asked.
When you asked, did you then ask for those memorandums again in your IDR?
Yes, I even say that.
And they did not provide that to you?
No.
Okay, thank you. That's all I've got.
Yeah, I even mentioned that my questions are from that memorandum. Yes.
Okay, thank you.
Yeah, thanks.
Members, Ms. Silva. So when somebody files for a discretionary review, can you walk us through the process a little bit so we know what Ms. Tseng spent her money on?
Sure. So discretionary reviews can be filed against building permits. Mm-hmm. And once a discretionary review is filed, it can be filed by a neighborhood group or an individual. In this case, I believe it was by an individual. We intake, there is a fee of a few $100s along with an application. It gets assigned to a planner and then reviewed and analyzed by our staff and then taken to a hearing before the Planning Commission. The Planning Commission then needs to determine whether to uphold or to further support the building permit or to modify the permit at that hearing.
Okay,
and so in this case, the hearing did not happen.
And so is not a member of the public, allowed a refund?
I believe they are in certain cases. I recall, I don't have the details of it for this particular case, but I do recall seeing a few emails between our finance staff and Ms. Tseng indicating that the fee had been exhausted because of the time and materials that staff had put into the project.
Yeah, I know, but it's not by her doing that the hearing didn't happen for it. I mean, I'm not necessarily advocating, I'm just trying to figure out in general, because I think she's correct in asking for, like, what happened to the whole process. It kind of fell apart and my money disappeared in some fungible general fund somewhere. So I think it's appropriate that if the Planning Commission does not have a policy of returning a appeals or somebody filing for a DR, I think it's appropriate. I mean, it's not in our jurisdiction, but I think that she should be afforded an answer as to, what happened and why.
Right. I agree. We do refunds, is my understanding, but I believe in this case the fee had been exhausted. So that was a previous determination by some of our finance.
Could it be possible that you can work with Ms. Sang to see if maybe she can process a request
our
for a
records and
refund?
see what happened there.
That would be very nice. I appreciate that. Thank you. Anything else, members? Member Canada.
I just have a follow-up question. So you're saying the discretionary review did not take place?
Correct.
And it would be the Planning Commission who did the review and had a finding on it?
Mm-hmm. They issue a final resolution.
So did the Planning Commission decide not to do the review, or did the Planning Department not even send it to the Commission?
The applicant requested withdrawal of the building permit, which then canceled the discretionary review hearing.
Which then generates 100% refund. I mean, I'm back to that again. Hate to say it, but...
So the applicant being?
The property owner / architect.
Okay, so the project was pulled.
Correct.
So there was no review. So why wasn't Ms. Sang notified of the reason and refunded her money? And again, that's not in our purview, but I ran a neighborhood group for years, and I know for a not-for-profit neighborhood group, the money is paid up front, but that money is refunded. So I don't understand the money was used up for whatever reason planning decided to use it for. So.
Okay, anything else? Okay, thank you very much. Okay, we have a motion. Sorry? Oh, I'm sorry. You're right. Ms. Silva, we're going to do rebuttals. You have 3 minutes rebuttal, no rebuttal. Ms. Sang, do you have rebuttal?
I think I said everything.
Oh.
At this time, I said everything I need to say.
Okay, very good.
I think the money, as you said, that even though it's not under your jurisdiction as a public member, we paid a fee for a special public hearing. I think that we at least are entitled to know what happened to my money. Why holding those things is so secret? To me, it's just like we won't tell you anything unless. If we file your order, I don't even get those 2 pages.
Okay.
Thank you.
Thank you. Okay. Now, motion.
I think it should be a motion to find timeliness at the very least. And I know it's not in our purview, but and may not be appropriate for us to send a letter to that person saying, we spent some time on this, and you may not have heard the whole story, but it seems like to us that once the DR is pulled, should there be at least consideration of a refund? Maybe something. I'd love to say it. I'm not sure we can, but anyway. So the motion is to find a timeliness violation of the IDR.
Can we also add assistance? Because it just seems like Ms. Sang had to do so
Agreed.
much work on her own, had to come here. I feel like I've seen Ms. Sang 3 or 4 times here.
I agree. I'll amend.
Okay. Thanks.
Okay, so moved by Vice Chair Hyland.
Second.
Second by Member Hensey. Public comment. Seeing no public comment, members, any last thoughts on the motion? Seeing none, let's call the roll.
Victor, do you want to get the correct codes in there?
I believe it's the same code section.
That's already there.
Actually, it may also include 67.21 and 67.25 for failure to respond in a timely manner and failure to provide assistance to the requester. It is.
And a full refund.
Sorry.
And would you like to add a note to the order of determination regarding a suggestion that, regarding a refund if
I don't think we can do that.
I don't think it's appropriate. I think we've asked the planning department to work with Ms. Zhang to try to effectuate that. There are other avenues if she's
Mrs.
not able
Silva
to
can
get it.
carry that torch for us.
Yeah.
I can add that to the statement that we've asked the planning department to work with Ms. Stang.
Yeah, and they've agreed to.
Yes. On that motion, there was no public comment on that motion. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Fisher, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. We can take a break and then do public comment. How about doing that? 5-minute break, real quick, and then we'll
I
do
believe the
public
next
comment.
item will be relatively short, with
5 minutes.
Okay.
I mean, is it going to take 5 minutes to do the next item?
It may take longer than that, just to go
Right.
through the wording.
Let's take 5-minute recess. We'll come back. We'll do public comment and continue. Thank you.
It's because
Item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I mentioned this, what I'm going to talk about, to Bruce in an email. Having attended several hearings of the subcommittees where the complaints were being initially heard, we're running into an issue where either the respondent or the complainant doesn't show up. And then the subcommittees are going, well, we don't want to do anything because we can't ask anybody any questions. And really that puts the complainant in a really awkward position. And I came up with a suggestion which I previously made to Vice Chair Wolf regarding another matter. During the hearings regarding the complaint against Eric Marr, they didn't show up for the hearings. And so I said, well, when you send them a notice for the next hearing, if you could put in there a sort of a warning that, well, if nobody comes, we may decide to proceed without you, and we may decide to find a violation for failing to send a knowledgeable representative. And so, lo and behold, somebody showed up. And what I'm saying is, if you're going to send out the complaint and say, well, the respondent and the complainant do not have to show up, put in there a clear statement saying that if either party decides not to show up, that the subcommittee will go with the information it has available in front of it at that moment, and will make their decisions and recommendations based on that information alone. So basically saying to them, well, if you choose not to show up, then you're kind of forfeiting your right to counter any argument that might be presented. And the same thing goes with the full task force. You know, if you can go back and forth, but if you put something in there that very clearly says to them, if you don't show up, we're going to use what is there as the basis for our discussion, basis for any findings of violation or recommending finding a violation, and that's your choice. Otherwise, we're going to end up going back and forth and back and forth and back and forth, where somebody will show up for the subcommittee hearing. Now, I can tell you how the city, you know, if I were with the city, how I would deal this. I show up to the subcommittee, and we have a hearing, and you vote to find a violation against us and recommend to the full task force that you do. Well, I'll maybe not show up for the full task force hearing and hope that maybe somebody on the task force will not feel comfortable voting for a violation because they couldn't ask the respondent, the city agency, questions. So unless you do something which kind of, you know, gives them that impetus to show up, and then at the same time gives you the tacit permission of them, I would say, to go ahead and make a decision based on whatever has been submitted by both parties at that time, I think this is going to be an unending shuffle.
Any other public comment?
I would like to use this as an opportunity to appreciate your time and effort to help me and some others listening, watching this processing who doesn't speak English or speak well English to obtain record from the departments. It's not easy. I hope that they get the message and get some guideline to put, not just try to not to comply with the law and follow your instructions. Thank you.
Any other public comment? Seeing none, public comment is closed. Call next item.
Next on the agenda is item number 8, file number 16084, complaint filed by Antrabo against Mayor Edwin Lee and the Office of the Mayor for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner. On January 24, 2017, the Complaint Committee reviewed the complaint and further referred it to the task force with a recommendation to find jurisdiction and find that a violation of 67.25 occurred by failing to respond to an immediate disclosure request in a timely manner.
Okay, let's have a motion for jurisdiction.
So moved.
Second.
Moved by Member Hensy, second by Member Kanata.
This is a complaint that was filed against the mayor's office. As we all know, they fall within our jurisdiction, and there are issues of not providing documents as well as timeliness before us, which falls under the ordinance.
Okay, thank you. Any public comment? Seeing no public comment, we take this by acclamation. Seeing no objection, item is approved. Okay, presentation.
So in this complaint, it was filed by Anne Trudeau against Mayor Ed Lee's office. It was concerning her request for documents, I think from 1995, I believe, or maybe 1999 to the present, about the appointment of an arts commissioner. And she was provided with several documents from the mayor's office, but she did not receive all of the documents. We were able to hear from the mayor's office, and the respondent explained to us that all the documents that admitted that the response was late, and this was before the current custodian of documents was in his current role. He also explained that all the documents that they did have, those incomplete, those were all the documents that the mayor's office did have. And then finally, he gave us specific details about their new protocol for retaining documents and responding to requests in a timely fashion to show us that this wouldn't occur in the future. Our recommendation here was to find that a violation of the ordinance did occur, that the IDR was not responded to in a timely fashion, but we did feel satisfied. So we do think that there were violations, as explained, but we do feel that the mayor's office was able to provide us with good information on their protocol for handling these requests in the future, as well as retaining documents on appointments of commissioners, their swearing-in documents, things like that, and how they're retaining those documents going forward.
Great, thank you. Let's hear from the parties. From the petitioner, Ms. Trudeau. Not present. Are there any persons or witnesses on behalf of the petitioner to provide any facts or evidence? Seeing none. Respondent, is the respondent here?
Good afternoon, everyone. My name is Victor Lim, Deputy Communications Director from the Mayor's Communications Office. I think Commissioner Tesfaye did a good summary, and again, we understand that we made a mistake, and it was indeed late. We apologize. My predecessor was out of office at the time, and since then, we've reviewed the case, and as summarized, we now have a strong policy moving forward to ensure that we have actually 3 staff members following up on all sunshine requests. And we also, per the last committee hearing, that we have responded to Ms. Tribble with a response saying that our office has indeed provided all responsive records that we have, and we have no other further records to provide.
Okay. If we have questions, we'll call you back up.
Thank you.
Are there any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? Motion?
We need
Questions?
rebuttals.
You have questions? No?
No, we need rebuttals first.
Oh,
before-
right, we will. Okay, that's right. Thank you for reminding me. Okay, rebuttals, respondent first. Do you have anything to add? No? Okay. And the petitioner is not here, so let's go for a motion now.
Move to find violation of 6725, not responding to an IDR in a timely fashion.
Second.
Okay, moved by member Kanata, second by member Hensy. Public comment. Seeing no public comment. Members, any last thoughts? Seeing none, please call the roll.
On the motion, member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon. Aye. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Let's call the next item.
Mr. Chairman, as we have listed the next item as a special order, we cannot start those for another 20 minutes or so. We are ahead of schedule. Would you like to move on to item 11 at this time?
Sorry?
Would you like to move on to item 11 for approximately 20 minutes and then come back?
If there's no objection, hold on. We have somebody who might have something to say about that. Yes.
I object.
Okay.
We're both here. If Mr. Hartz agrees, we can we waive our right to the 5:30 special setting?
Were they the requesters?
We would just need to wait until 5:30 to take a final action, I believe, as we really should wait until 5:30.
Where was this?
Through the chair, who made the request?
That is something that I've been doing recently to prevent parties from having to sit through the first 2 hours of the meeting until we get to their item. I have been pretty good at predicting when we get to items.
Okay, but
However, in this
we're
case-
here. We're here now, and both parties are here, so there's no concern about anybody being late. So,
Through the chair, I think if there was a member of the public who particularly wanted to hear this case, I think as long as we hold off public comment on any motions so that that person could show up, but then again, they would have missed the first 20 minutes of discussion.
fair enough.
This is a nice problem to have. I don't think it's one we'll have too often.
Okay. No, I hope we have it more often. Member Wolf.
I'll retract my.
Okay. Okay.
I mean,
Member
I just
Moss.
wanted to say that I know if I was a reporter who wanted to cover this case and I saw on the minutes that it's in the agenda that it said 5:30, I would show up on time.
Okay,
And
well,
not,
there-
and
Through the
be
chair.
irritated if it started early.
And in 5 years, that has happened never.
Okay. Okay. All right. So is there, well, the same goes for moving an item up from another part of the agenda. Because it all was, but let's put it this way. The special order was specific, it's as noted on the agenda, is specific for only 2 items and not for any other items. So if there's no objection, we can move and discuss as much of item 11 as we can, and we can come back to it later in the meeting. Is that okay with everybody? All right, let's do that. Okay.
Item number 11, file number 16093, review and possible amendment to the Sunshine Ordinance Task Force bylaws and complaint procedures. Where were we?
Where did we leave off the last time?
I believe we just to state, in your packet, I have included a new version of the complaint procedures, which includes all of the recent approvals of changes to the complaint procedures. I tried to put your requests into words and into the complaint procedures for your review. I believe at this time, concern regarding the complaint hearing process has come up, and it's been brought up by several members of the public and members of the committee. So I don't know if we want to review our hearing process at the committee level or.
Well, we do have some discussion among various chairs of the committees, and I've gotten some communications from members of the public about it also, so I think we should have a little bit of a discussion on that. So this would be a discussion about, I guess, attendance of parties or requirements for attendance of parties during the complaint process. Right now, we have a requirement for attending at the full task force hearing where we meet on today, rather than at the complaint level. We had started this discussion at the last meeting, and I think we kind of came to some conclusion that we should flip it around, that the requirement should be at the committee level. And if all things are met at that point, then at the task force level, there's no need or there's not a requirement to appear. The point being that if a party finds no contest, then it's kind of a done deal at the committee level. And when it comes here, it still would be the same result. So, discussion. Member Canado.
Excuse me, just so I understand that if both parties are required at the committee level and then a party does not show up at the full board, does this body then just take the recommendation of the committee and vote on it?
Yeah, we'll go through the hearing process, because you never know 5 days before the hearing. There could be some new evidence, or documents that could be provided.
Through the chair, just to answer your question more fully, no, we will still go through, and if there's no one to stand up for, let's say, the respondent, then we will make the best determination we can based on facts and evidence before us. But I think the onus would be, I think I like where you're going with this, because at the committee level, we're sorting out the apples and the oranges, and we're getting it packaged for the full task force. And on top of that, I think it'd be very evident to both parties what direction they're going to hear the recommendation the committee's going to make, and they'll know whether it's worth their while, or whether they should show up or not to further explain or answer questions on a case. So I think, I was leaning towards saying, and I've heard people say in the past where, once a complaint's filed and packaged and gets to us, the complainant does not have to be here. It's partly our job to represent that complaint. And I've heard that from old task force members and other members of the public say that, and I agree with that to an extent, and that the onus is really more on the departments to be here. So I'd almost like to see that they both need to be at the complaint committee, and the department needs to be here at the actual full task force hearing, but that might not be where we end up, but that was my initial.
Okay. Member Wolf, Josh Wolf.
So, in many ways, it makes sense to call on the respondent, the department, to be there at both meetings, but that may be too much of an ask of the departments. I'm concerned about making the committee mandatory and the general task force not, to the extent that if there is something that comes up that wasn't recognized in the committee, particularly something that is unearthed that's a legal matter, that having the benefit of the city attorney here for the larger meetings, we're sort of disconnecting there. And so I'm not sure what necessarily makes the most sense, but not requiring them at the meeting where we have the full task force and we're actually making the decision is problematic. And if we don't require them to be at the committee meeting, setting expectations for them to come is also problematic, because unlike the complainant that can decide based on their schedule whether or not they can come to this and the other meeting and that sort of thing, when we're talking with members of staff, I'm assuming if we don't say it's required, there's an entire process within their department about allocating the hours to come to the meeting, and not all departments are necessarily going to handle that the same way.
What would you recommend?
I see a problem with the. I've been concerned about the way that I haven't seen a solid way to make the complaint committee actually work within the confines of the text of the language. And so I've seen these problems handled in different ways during my tenure on the task force, but without rewriting the language, I'm not sure that I see a really ideal solution.
Okay, so my interest in trying to facilitate the process was to have as little adjudication as possible at the complaint committee level. That the point is to make sure on nights, on the task force meeting nights, there has been lots of times where we've gone down serious rabbit holes for hours trying to figure out what the hell is going on with a case, because one side says one thing, the other side says another thing. It's sometimes completely apples and oranges, or the respondent didn't understand what the request was about. And I think the opportunity for having the complaint committee hear the case is really just to ferret out all the misunderstandings, make sure that everybody is on the same page. This body has heard cases many, many times with parties in absentia. We did that tonight, actually. And so that's the goal, okay? So that everybody should have the benefit of all 11 or 10 of us that are here regularly to have the case be heard by this en banc, okay? That it should not be heard by just 3 people and adjudicate at that level. So that's kind of the goal here. So if we kind of look at it from more of a pre-briefing versus adjudication perspective, I think that's what's important here. If you require them to show up at the committee level and you get all the information, you can ask for all the information. They say, well, we need 2 months to look for this. Okay, we'll continue it and not necessarily burden the task force, in its limited time on the first Wednesday of the month. Okay, I've got Vice Chair Hyland, then Member Tesfaye.
So just listening to the discussion, particularly by Member Wolf, there's a balancing between requiring too much time or too big an ask of the department heads and sending the employees here and overtime and all that. However, as we've seen tonight, how effective the complaint committee has been, and thank you, Member Tesfaye, for the excellent reports, summaries. We've never been this far on our agenda at this point, ever, in the 5 years I've been doing this. I think that says a lot of requiring both parties to be at the complaint committees to really sort it out, and I would be a strong advocate of that. What I was going to propose is to have both parties required at the complaint and the respondent required at the full task force, and maybe continue this, and revisit in a year. If we get too much pushback from departments, perhaps we can reconsider it. But I would be willing to bet that the 30 minutes or so spent in committee and the 30 minutes spent in the full task force meetings is a very efficient use of time, rather than just having the respondents, members of the government, show up in the full task force meeting. We take an hour and a half to sort out the apples and oranges. We have to continue it. They have to come back a second time. That takes a lot more time. I think this is going to be a much more efficient way of doing things. And I would say let's give it a go for a year, and we can always, the chair can always come back and revisit this if we're getting too much pushback or we're just taking too much time of government employees.
Okay, I've got Member Tesfaye.
That's a motion, I guess.
I got Member Tesfaye, Member Kanata, Member Joshua.
From my experience so far on the complaint committee, I would rather have both parties available for the complaint committee, and they can have the opportunity to both appear here, but not make it a requirement. At the complaint committee level, we're really trying to just do fact-finding. In the cases that we heard today, any information that we got from the individuals that were present were just clarifying. All of that information was already in the packet, which means all of the facts were already present for us to make the decision, because there was some additional information, and that was because the complaint committee wanted them to go back and find some information, include it in the packet. I think Ms. Sang's case is a good example for us here, where the complaint committee let it go forward as we were getting things together, and it had to be continued. And that shouldn't have happened. It had to be continued here. We had heard from her in the past on that same case. And so the complaint committee is really learning about the tools that we have. We don't want to keep anyone from being heard, but we want to allow people to get their facts together. So we're making sure that we continue items where facts are missing, so they can come back before the complaint committee with all of the facts before we send it to you, so we don't waste the time on our one meeting of the month. And we will continue to do that. So I don't necessarily think that the respondent or the complainant should be required to appear before the full task force, and they should be given the opportunity, especially given, whatever hand we might kind of reveal at the complaint committee level, if they want to argue legal issues. But the fact-finding portion should already be done, and any questions that you're asking them should be from information in the packet. When they're at the full task force, they should not be pulling up new information or giving new facts that aren't in the packet, because then you know what's going to happen. I don't think it's fair for us to vote on it at all that night, because we haven't been given enough time to inspect it. So that's how I feel about it.
Member Canada.
Well, I could agree to having the respondent have to appear in both meetings, but I think there should be an option for the respondent, going back to the last case we just heard where Ann Trabeau against the mayor's office, where if at the committee level, the committee is recommending that the full body find violation. With this last case, the mayor's office agreed that they had a violation. Is there a possibility that at committee level, if that type of finding happens, that the respondent waive the full hearing and just contact the full body and say, we agree with the committee finding, let's not have this appear? In this way, the committee level has done the job. The respondent's case, they admit there was a violation, and we don't have to spend the time to hear it again.
And then but the final order determination has to be done here.
The final order is done here, but it takes 5 minutes instead of however long it takes.
Okay, I would. My only response to that is I agree with the due diligence on the committee's part, but I think it's important that there be a presentation of the case so that when you're making, it's just not a rubber stamp. Okay, that everybody knows exactly what they're voting on. I think that's a really important factor here. And I'm trying to make sure that that's, because if you're part and parcel to a vote, then you should be knowing what you're voting on, right? So, sorry, Member Josh Wolf.
So we're coming close to that 5:30 time point, but I'm curious whether we can, even if we choose to as a body, require the respondent to be at both the complaint committee and the full task force. Like, I want to know whether that's within our ability and purview in the first place. And then secondly, I just go back to the fact that, like, we can take a look at the cases of this evening or past cases, but then you come across the ones that end up not quite as expected. And I don't feel comfortable being in a position where we're not able to essentially fully assess the situation, and that means having both sides there to answer our questions.
Okay, so my what I am willing or will do is, if we're reaching a point, let's say at a 20-minute mark, we can't figure out what the hell's going on. If it becomes so untenable, I will send it back. I will recommend that it be sent back to committee. And then committee will have to, work out whatever the misunderstandings or the discrepancies or the, arguments or conflicts there are at that point. I don't want to waste our time here to do that. I think it's better spent at the committee level to have the time spent there. What do you think about that?
That's all fine. It's all about who we're requiring to show up is my only concern in this matter.
Yeah, we can require respondents to show up both times, but I think that's been kind of the angst for many, many years that they've had, that it's a lot of additional staff time, and everything's counted by FTE here. So, the point is how do we get the best bang for our buck? As taxpayers, how do we get them to show up and for it to be meaningful, to get everything that we need, so that we can make the proper decision. I think that's really the kind of thing. I hear you. I would like to do that, but our experience in the past is they just don't show up then, and they'll either show up for one and not the other, and then you end up with dealing with all the misconceptions at the first hearing of the month, or you end up with not enough information that was provided at the committee level for the task force. So, Vice Chair Hine.
Just to give some perspective on, just to look at how much time department members are spending here. I think ever since I've been here, it's been the other way. They show up to the first meeting, and then they show up to the follow-on, compliance amendments, EOTC, all the other ones that go past it. It's only in the last 2 or 3 years have we really started to use the complaints committee to get them before us to sort stuff out, and under your direction, even tightening that up even better. So I think, if we require them to come to the, come to the first committee and the full task force, I think in many cases that might be it. We had the previous chairs have continued a lot of things down the line to, compliance and EOTC, and, those could be voluntary, especially if those documents or those standards or whatever have been met, ensuing the final order determination and they're in compliance. So it's kind of like front loading it rather than back loading it.
Yeah.
And again, I think over time it might be more efficient. I mean, it sounds like we have an agreement, I think, of the body, and correct me if I'm reading it wrongly, that we require them both to be at the complaint, and then the question is, maybe we can take a second vote on, do we require the respondent to be present at the task force? And those could be the motions on the table.
Okay. And, this is kind of a tweaking process, so we can revisit this, let's say, 4 months, see how it's going. I think, for 4 meetings of committees and the task force should be enough to figure out whether it's working or not.
Or even longer. Maybe I was thinking end of the year.
Well, if it's not working, at least check in. Let's check in 4 months and see how it's working. And if we need to tweak it, then not. So you made a recommendation to split the question. Okay. So shall we make the requirement now for parties to appear during for the at the complaint committee level?
Is that the first?
That'd be the first. I'm asking for somebody to make a motion, but Member Josh Wolf, you have something else?
I mean,
before we do that,
I'm not. I don't think we should split the question. Actually, I think you should propose the motion with what you're asking for, because if we're just asking should the respondent be at the committee level or at the complaint committee, I think that's an easy yes. But if I'm asked to choose which of the two to be at, I actually am concerned about them only appearing at the complaint committee, because it really does change the role of this body in relation to the complaints in a way that I'm concerned about, but I don't think we need to discuss.
I'd like to make a motion. Oh, Victor.
We can also add the option to give the committee the option to require the party to show up at the task force if they believe that they are required to answer additional questions. We have done that in the past, where we ask the parties to come back.
Okay.
Specifically to the complaint committee, as we need to ask questions, so you have to come back.
Okay, so somebody have a motion?
I'd like to make a motion to have both the complainant and the petitioner and respondent appear before the complaint committee.
Second that.
As well as.
Do you want to?
I'm splitting the question, so all I care about is my committee.
Okay. Okay, so let's do public comment on this.
Should we propose a second motion and then have comment on both?
No.
No.
Should we move on to the 5:30 special and come back to this, as this may take some additional discussion?
Yeah, probably. Well, we've got a motion on the floor. Let's get through with the motion, and then we can deal with the other item later.
Ray Hartz, Director, San Francisco Open Government. Now, I've been doing this for a few years now, 8, 9 years, and I have one concern, and it goes back to what I talked about during general public comment, which is making a little more clear in the letters or of notification what the expectations are. And the reason I'm bringing it up again is that one of the issues that comes up if something is referred to the Ethics Commission is the very real possibility that one of the parties, in particular the respondent, would show up and say, I didn't get due process. I wasn't at a hearing and they made a decision in my absence, and therefore the whole thing is a bunch of baloney. And unfortunately, given the fact that the Ethics Commission has no tendency whatsoever to enforce the rulings of the Sunshine Ordinance Task Force, I think that's a very real concern. I'll give you an example. The referral 9-0 of the case against Eric Marr went before the Ethics Commission, and they voted 2-2 not to find him in willful violation. And one of the members, Beverly Hayon, who was a former library commissioner appointed by the mayor to the Library Commission and appointed to the Ethics Commission by the mayor, proceeded to sit out and talk about how the fact she didn't like that people were using the Sunshine Ordinance to harass city departments, how they were asking for information that she didn't approve that they asked for, and so forth. So what I'm saying is, whatever you choose to do, place some language in the letter of notice that says, if you make the choice not to come, we will or may choose to proceed in your absence, and that does not negate whatever findings or decision we may come to, because you're choosing not to come. Same thing goes with the full task force. I'm the respondent. I don't file these claims for grins and giggles. I'm serious, so I come to every hearing, and that's my choice. And I know that some complainants don't, but I can't quite figure out why. I want to know, if I file a complaint, the entire process from A to Z. I want to hear all of the arguments, all of the claims, and all of the information, so that I can decide whether or not the whole process in my hearing, the complaint I filed, was handled in what I felt was appropriate manner. But my more important concern is the notices to the complainants and the respondents are very vague, and I think they need to be worked on. And I would be more than willing to send in some suggestions you could look at. Like I said, the one we did with Supervisor Marr got somebody to the session.
Okay. Is there is there any amendment that you want to make to that, or be based on public comment? I mean, I think one point he made that I think was good was putting in some notation about either that the item might be heard in absentia, that kind of thing.
Can I make a comment?
Yeah.
I think that language doesn't hurt, but in either case, as long as the notice specifically lists the violations that are at issue, and that the person receives it and knows it, and then they have the opportunity to appear or not. And so they've received their due process. I'm not, concerned about them making a due process complaint. The notice was sent to them. The violation needs to be specific on there, and they are giving the opportunity to attend or not. Even if we're not making it a requirement for them to attend, they still have the opportunity to come and speak in their defense or on their behalf. So I'm not too worried about that.
Okay. Any other comment? Any other public comment? Seeing none, let's call the roll.
I would like to set an effective date, if possible, of March 15th, as I have issued a notice of hearing for the March 13th Compliance and Amendments Committee with the old language. So if you can set an effective date of March 15th.
I'm sorry, say that again. You've already set
I've already sent out a notice for a March 13th meeting stating that the parties do not need to show
for which committee?
Compliance and Amendments.
So
there's two items.
So I want to put it out to the choice of the chair of that committee whether they want this to be active or not. I mean, the point is we're making this decision now so that we either make a correction or an adjustment in the process.
Through the chair.
Hold on. I've asked the chair of the committee first.
I think if we can get notices out to everybody who's going to appear at that meeting, that this is our new policy in the next day or so, that would be fine. But if not...
It already went out, though.
But it's still 12 days before the meeting.
Right. If we can get it out next day or two, so it's 2 weeks, before the meeting, that would be fine. If not, then we could start with the next.
Okay. Vice Chair Hyland.
Just, I guess, a point of order. The motion is pertaining to all subcommittees?
All committees that hear complaints, that are authorized to hear complaints. So there are 3 committees: the Complaint Committee, EOT, and Compliance and Amendments.
Okay, I just want to clarify that because... all right.
Okay, Member Moss.
Yeah, no, I thought we were talking just about the complaint committee, and just wanted to raise a question that, with that requirement, so the complaint committee meets every month, but compliance and amendments only meets every other month.
This is only for complaints that you're assigned.
Right. So in the event that somebody can't make it, then that may end up pushing somebody's complaint out another 2 months.
What do you mean?
Or another, it'll be, so say for whatever reason a person who is required to attend cannot attend due to a family emergency or a surgery or something, they're going to ask for a continuance, which is going to push that much further than if it had come before the complaint committee.
Why? You have the same ability to do things as the complaint committee.
Well, but complaint committee meets every month, but compliance amendment meets every other month.
Okay.
So it would be pushing, for certain complaints who come before those committees that meet every other month, a continuance would push the complaint out further.
And so what's the problem with that?
I mean, it's just a timeliness of getting something done.
Well, I think the only thing that's really of any concern is the 67, 21, and 25 with regards to the 45-day rule. And all you have to do is find whether the records are public or not. That's it. Okay? There's nothing more to concern yourself with regards to that part. So then once that part is met, then you can continue the item ad infinitum if you want. So
I just know that if I was a complainant, I probably would not want my complaint coming before a committee.
Well, you have the option of contacting me and saying, it looks like this is going to be continued. Maybe can it be referred to the complaint committee instead? Sure, no problem. We can do that.
Let me just restate my through the chair.
Sure.
So what I was trying to get to is, are we still operating where the meeting that day starts as compliance and amendments and then moves into complaint committee? Or is the compliance and amendments committee has complaint committee duties and rights?
According to our bylaws that were changed in 2012-13, the other 2 committees, EOT and CNA, are authorized to hear complaints. So however the agendas get organized, they get organized.
Okay.
But usually I don't know how, nowadays, you usually have a complete split, items that are specific to the charge of the committee will go first, or vice versa, and then the complaints will be clumped together.
So just for noticing, I just want to make sure that we're getting the language right, that, all petitioners and respondents must be present at the first subcommittee meeting.
Well, it's at the complaint process, the committee that's hearing the complaint.
Okay.
Member Joshua.
So I'm just a little confused about Maz's concern. So if someone has a complaint that's appearing in front of one of the 2 subcommittees that's not the complaint committee, and that subcommittee is canceled, those cases aren't wedded to that complaint that particular committee. So wouldn't Victor naturally just move them to one of the other meetings so that they don't sit around for 4 months?
I don't know if that's a natural occurrence or not.
It's a possibility, and if no other actions were taken, if they didn't start the hearing at all, I would try to move it to another committee for timeliness.
Yeah, as long as the first committee hadn't heard it, I think it's fine to kind of move them around, to move it to the complaint committee. If the complaint had already been heard and then continued by that committee, then I think it should stay with that committee.
Right, but I was just, if it hadn't been heard before, I was just making sure that they weren't essentially married to a random subcommittee for some reason.
No, and I would put it this way. I think each and every one of us is competent enough to be able to hear cases. So even if it did happen to get moved, maybe because committee members couldn't make it for a certain meeting, or there was a event happening that the committee we couldn't get a room for a committee, that I think any other complaint committee that would hear it would be fine. The purpose, again, is not to adjudicate. It's a pre-briefing to collect information. I think any one of us has the ability to do that. Okay? All right, let's go to a vote.
On the motion, Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Chair Wolf.
Aye.
Wolf, aye. The motion
Wait,
passes.
how about me?
Oh, did I?
Skipped over
Oh,
the
yes,
maker
sorry.
of the motion.
No X. Member Tesfa.
Aye.
Tesfa, aye.
Who seconded it?
That was seconded by Member Hyland, Vice Chair Hyland.
Okay, great. Thank you. All right, great. Okay, let's get back on schedule here.
Motion to continue the item?
The other item, we'll take that up after the next two items.
Item number 9, file number 16116, complaint filed by Ray Hartz against Commissioner Quentin Kopp and the Ethics Commission for allegedly violating Administrative Code, Section 67.15D and 67.17 by abridging or prohibiting public criticism of the policy, procedures, programs, or services of the city regarding the Ethics Commission December 20th, 2016 meeting.
Okay, motion for jurisdiction.
So moved.
By Nancy.
Second.
Second by Member Fisher. Chair of EOT, do you have anything to add? I will, but Chair of EOT?
Oh.
Do you have anything to add on jurisdiction?
That was us.
Not on jurisdiction, no.
Okay, great. Public comment on jurisdiction. Seeing no public comment is closed. We take this by acclamation. Seeing no objection, item is passed by acclamation. Chair Josh Wolf.
Sure. This was one of a couple cases we heard that were sort of along the similar lines of what governs public comment. In the case of Hartz's presentation, he was... Sorry, I don't have this up in front of me, but basically he was interrupted it was about whether or not people can actually be identified.
Would you?
Thanks. We had two very similar cases in form to this.
If you would let me, I could provide a short summary.
A summary? Okay.
Yes.
I just want to get the gist of what it is. And then
I believe that during public comment for item number 8, Commissioner Kopp made a short interruption.
Item number 9.
On their item number 8, Commissioner Kopp made a short interruption stating that Mr. Hart made a statement of excuse my French, and Commissioner Kopp stated, I will not excuse your French. Therefore, slightly interrupting the public comment of Mr. Hart by about 8 to 10 seconds. I did review the audio, and additional time was not provided back for that 8-second interruption by Commissioner Kopp.
Okay.
And that is the question.
Okay, let's hear from the parties. Petitioner.
Ray Hartz, Director, San Francisco Open Government. And basically, all you need to do is look at the recording. The Executive Director's response on page 509 of your packet. I'm sorry, 510 says it's at timestamp 1 hour and 37 minutes. I started my public comment. If you watch the recording, you will hear the 30-second chime. I go on for maybe 10, 15 seconds longer. And I used the term bullshit, and I said, pardon my French. And Commissioner Kopp then interrupted, said, I don't have to excuse your French. I don't put up with profanity. Got up and was walking around behind the podium. And then you can hear the 3-minute chime. And so basically I said, do I get compensatory time for that? And the chair, Mr. Keene, said, no, your 3 minutes are up. So basically my comments were abridged, and the Executive Director's response here conflates a whole bunch of other things which have nothing to do with that very simple set of facts. I do not dispute the idea that under 6717, members of a body have the right to respond. He certainly has the right to respond, but he needs to follow the same rules that everybody else in the chamber is expected to respond. When my public comment is done, he asks for recognition from the chair, and on recognition, he is free to say any or all of what he said. If he had been silent, if he had simply turned his chair around or gotten up and walked out, then I would have had no objection because I would not have been interrupted and my comments would not have been abridged. But they were abridged at the point where I was summarizing everything I had said previously, and the facts clearly show an abridgment.
Are there any persons of witness to provide any facts or evidence on behalf of the petitioner? Seeing none, respondent. 5 minutes.
Hello, Jessica Bloom, Deputy Director of the Ethics Commission. I want to start out by correcting the facts slightly. I believe that the task force's Education and Compliance Committee found that the violation occurred in regards to item 11. I reviewed the tape again today, and on item 8, Mr. Hartz begins speaking at 1 hour 37 minutes, and he ends precisely at 1 hour 40 minutes, and then the conversation about the first swear word, BS, occurred. So the Education and Compliance Task Force don't reference 2 violations, but the 7 to 8 second violation clearly happened in the second item, which was at item 11. Mr. Hart spoke. He begins speaking at 2:11:56. He swore at 2:14:01. Commissioner Kopp interrupted him at 2:14:03. 7 to 8 seconds goes by, and then Mr. Hartz concludes without being granted additional compensatory time. So the Ethics Commission doesn't dispute that Commissioner Kopp's admonishment to Mr. Hartz interrupted his public comment time, and he lost 7 to 8 seconds, and we're not here to dispute the findings of the Education and Compliance Committee. Our primary defense is that Mr. Hartz received a lot of public comment time during the commission meeting over all of the different items on the agenda, including his specific case that was before the commission, which we gave him extra time to make his arguments about Supervisor Marr's violation of the Sunshine Ordinance. So we would just argue that this was a de minimis violation in light of the Sunshine Ordinance's purposes. 7 to 8 seconds is clearly not a full abridgment. No one told him he needed to stop talking or yelled at him for criticizing the body. Mr. Kopp had an exclusive concern about his use of profanity, which I think Mr. Hartz would admit that he used, knowing that he had already been told not to with regard to swearing in a previous public comment period. So that's all that we can say.
Okay, thank you. Are there any witnesses or persons provide any facts or evidence on behalf of the respondent? Seeing none. Members? Member Canada.
I have a question for the respondent.
Yes.
So does the Ethics Commission have a policy on how to handle these issues? And the reason I ask is we had a prior case where an individual was interrupted, but the person keeping the time kept the time. And after all the interruptions and back and forths, because of the interruption, the person giving comment was allowed to continue and finish their 3 minutes. And in this case, it seems like the person making public comment, Mr. Hartz, was not allowed to continue and get his full 3 minutes. So is there any type of policy?
There is. Thank you for asking. The Ethics Commission, as a general rule, always pushes pause when the commissioners ask questions. I think that the issue this time was that Judge Kopp's wasn't really a question, and he stood and left the dais. So I just don't think that the timer understood that constituted an interruption. But we've spoken to all of the minutes takers and the people who would be instructed to push, who would have responsibility for pushing the button, to make sure to always listen for whenever a commissioner speaks, hit the button regardless of whether it's a question.
Okay, thank you.
Member Ross.
So I don't have a question for Mr. Hartz, but he might want to respond to my comment, so I thought I'd invite him up anyways. So I have some criticism both sides and how this complaint read when I was looking at it. So your complaint never actually mentioned anything about what item you spoke on, and so I was a little bit at a loss for what you were complaining about, and then I had to go off of the respondent's timestamps and assume that the respondent was actually identifying what you were complaining about. I think that it seems like you're okay with that because you referred to the timestamp that the respondent pointed out, but I just wanted to point out that it was very difficult for me to figure out at first what you were actually upset about because there was you spoke like 9 or 10 times at that hearing, and so it could have been any of those times that you were angry about without further guidance in your complaint.
Just a very quick response is the fact that, yes, in item 8, which was the 137, that was the area where I was clearly abridged. I was cut off. She says 17 seconds. I'll take her word for it. And I did ask for compensatory time and was denied that. So it was clearly abridged. The second number on item number 11, I got up and made the comment that Supervisor Malia Cohen had both used that very term in a Board of Supervisors meeting that I attended, and she had also referred to Mr. Petrellis in the interview of one of the members of this task force without saying his name and calling him, you can make a public records request without being an asshole. And I got up that second time just to make the point that if members of the Board of Supervisors can use those terms, then how can other boards and commissions say, oh, no, you aren't allowed to use them because they're profane? It's kind of a constitutional minefield where it's like, okay, so anybody on the board can decide any word they said is profane and they can just interrupt public comment and use your time to raise that objection?
No, that makes sense. I just would have been totally lost if it hadn't been in the respondent's letter. And then as far as the respondent's letter of February 14th, I went through the video and I had a lot of concerns that the information provided in the letter did not match to the video in the order that things happened. I think that the committee has probably addressed it now that I'm hearing from the committee, that you guys found or made a recommendation of the violation. But there were things in here like Commissioner Kopp never left the hearing room. When I was looking at the video, when it cuts back to the full, Mr. Hartz is still talking, and when it cuts back to the wide shot of the room, you see Commissioner Kopp actually re-enter the room. There was issues with when, I think in the letter it says that after the comment timer alerted Mr. Hartz that his 3-minute period for giving public comment had expired, Mr. Hartz added, and then there's a line that he added, and it didn't actually occur in that order. The time was up after he had said that remark. So anyhow, I just wanted to raise some concerns about when I looked at the tape and how it matched up to the document we were provided.
Thank you.
Can I ask a question of Member Moss?
Sure.
But you're not, whether Commissioner Kopp was in the room or not, you're not considering that part of the abridgment of the time, right?
No, I'm considering, I'm just looking at the facts that have been presented to us, and I'm concerned that the letter that was provided to us by the Ethics Commission is factually inaccurate.
Okay. And I have a question for both Mr. Hartz and Ms. Blum, whoever would like to respond to it. You can also as well. But I thought I heard 7 to 8 seconds, and then I heard 17 seconds. So which is...
My review is 7 to 8 seconds. I think the Education and Compliance Task Force found 10 seconds.
Okay.
In the findings that we were given.
And this is the time period when Commissioner Kopp is speaking, not when he's up and walking around, right?
Right.
Okay.
And I'll add that I was in the meeting, and Judge Kopp did not leave the room.
I mean, whether he left the room or not, I want to make it clear that that does not constitute an abridgment of someone's public comment. People can get up, go to the bathroom, whatever they need to do as a human being, and that's not abridgment of someone's public comment. So,
But at the same time, if they get up and leave their chair and they leave the room, it means they're absent under
that can make
Robert's
sense.
rules.
That's a different from abridging someone's
I understand
public
that,
comment.
but if you're going to get up and walk to the back of the room and you're a voting member and you make a comment like that and it somehow disrupts the flow of the meeting, they're not necessarily present.
Okay, but that's I think a very important distinction is all of us here get up all the time to go to well, I get up and people can get up, and that's not an abridgment of public comment.
No, I agree.
Okay.
I agree. I'm just saying that if they were to speak
Speaking
out
is
of
different.
their
So that's
chair,
what, yes, you're
then
right. I agree, and that's why I wanted to know the distinction, because I heard Mr. Hart say 17 seconds, and then I thought I heard Ms. Blum say 7 to 8, and then 10.
I'll add that we would admit that had Judge Kopp left the room and there had not been a quorum, that certainly would have abridged his public.
That's different, yes.
Yeah, but there was a quorum there at all times.
Okay, thank you.
Great.
And just a quick response to Member Tesfai's comment is, I'm not saying anything about them getting up and walking. Like I said in my presentation, if he had simply turned his chair around with his back to me, or if he had gotten up and silently walked out or away or whatever, there would have been no interruption, and I would have just continued. I would have finished, and it was all over. But he didn't. He felt that he had the right to interrupt my comment, to make his objection, and then when I asked for compensatory time, that was denied.
Member Josh Wolf.
So just it's Education, Outreach, and Training Committee, not Education and Compliance, which sounds a little spooky. It's fine. And then in terms of the actual seconds, we did in the Complaint Committee ask Member Hartz to either bring in the transcript or recording of it for the full task force, but at the meeting that we had, we didn't have that, and we just had Mr. Hartz as the sole attendee to the complaint. So the specifics may have gotten written up that way, but they weren't really exactly addressed in such a finite level. It was really more a matter of the Complaint Committee recognizing that there was an interruption that took time away from Mr. Hart's public comment. And so it seems to me that although there's some finer points that are outside the scope of the actual violation that are in disagreement, everyone in the room seems to be in agreement that Mr. Hartz had this time taken away and wasn't recompensated for it.
Okay. Any other comments? Any other questions? Clarifications? Okay, let's go for rebuttal. Respondent first. 3 minutes for rebuttal.
No rebuttal.
Petitioner.
Sure.
Having gone through years of dealing with making public comment, I have gotten pretty inured to the idea that sometimes when you make comments they don't like, they want to shut you up. And if they can't shut you up, they want to keep it out of the official record. And my history with this task force has been one of being able to say the things that need to be said. And they usually don't object if you're praising them. They only object if you're raising an issue. And they try to keep you from saying it. And if they can't keep you from saying it, they try to write the minutes so that it doesn't show up in there. And then if you can't keep from doing that, then it becomes other things. Then it becomes becomes your language and your tone and all these other issues, which really have nothing to do with the matter. I've said it before. I've never had anybody, correct me, including members of the ethics, 4 out of 5 members being attorneys, one being an emeritus law school professor and the other being a former Superior Court judge. When you appear in one of these meetings at City Hall, it is constitutionally protected political free speech from beginning to end. And any abridgment of that is a violation of someone's First Amendment rights, not to mention the Brown Act and the Sunshine Ordinance. And not one person has ever said, no, it's not constitutionally protected political free speech, and it is. And it rises to the highest level of protection of any form of speech. That's been ruled numerous times over the years by the Supreme Court of the United States. And because Judge Kopp didn't like my language, he felt free to interrupt me. And again, what would they do if I were to stand up when Judge Kopp said something in a Ethics Commission meeting, stand up as a member of the public and say, I don't like that, I don't like you using that language, and then walk around in the front of the room? I would submit to you that they would either tell me to shut up and sit down, or they would have the sheriff pull me out. I don't have that. They have power. In this case, they chose to exercise that power. And I think if you were to look at the next agenda item, which was item number 9 on their agenda, at the end of the item, Commissioner Keene says, oh, Mr. Hartz, would you like some extra time to talk about what you wanted to talk about on the last agenda item? And I replied, no, that's not the way the rules work, and I'm not going to do something illegal to compensate for something that was done to me illegally. I follow the rules, and all I'm asking is that members of every board and commission, including ethics, including Commissioner Kopp, simply follow the same rules that they expect everyone else to follow.
Okay, members, motion.
I move to find a violation on 6715 for interrupting public comment.
Second.
Moved by Member Kanata, seconded by, I'll go with Member Moss this time. Okay.
That was 67.15.
15. Yeah.
67, what, 15?
15. Okay, public comment. Seeing no public comment, any last words from us? Okay. Let's go for a roll call.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Fisher.
I'm reading. Can you come right back to me? I'm just reading 15 right now.
Member
I
Hinsey.
did this one. You know what? Yes, sure.
Member Fisher, aye. Member Hinsey, aye. Vice Chair Hyland.
No.
Hyland, no. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Cooper, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion
Thanks for
passes.
reminding me.
Call the next item.
Next on the agenda, item number 10, file number 16117, complaint filed by Ray Hartz against City Librarian Luis Herrera and the Public Library for allegedly violating Administrative Code Section 67.29-6 by failing to disclose the amount and source of all outside funds or services worth more than $100 in aggregate accepted by Public Library for the purpose of carrying out or assisting any city's function on their website.
Motion for jurisdiction.
Moved.
Moved by Member Fisher, second by Member Hinsey. EOT, anything to add for jurisdiction?
I mean, there's the jurisdiction isn't particularly complicated, but it does intersect with the Friends, so we there are potentially elements. The library wasn't there. So there does appear to be jurisdiction, but there's enough connective tissue that potentially there could be complications as we unpack it further.
Okay, great. Public comment on jurisdiction.
Through the chair,
Yes.
I was at that meeting, and I'm starting to conflate some of the cases. Victor, was this the one where we punted because we wanted to have DCA Cola here, or?
I believe that the committee narrowed the question down to one very specific issue, and I believe after we find jurisdiction, we can discuss.
Can
We
we?
haven't found jurisdiction.
No, we haven't. Let's get to that first. All right. Any public comment on jurisdiction? Seeing none, can we take this by acclamation? Seeing no objection, item is approved by acclamation. Okay, now
All right.
you can ask your question.
The question I asked.
I believe after discussion, it came down to one question. One moment. Pursuant to the minutes, the committee requested that the respondent provide a detailed response as to whether or not there is a written agreement that the Friends of the Public Library abide by the Sunshine Ordinance as if such and if the first part is a statement of whether or not there is a written agreement with the Friends of the Public Library to abide by the Sunshine Ordinance pursuant to 67.29-6. The second part of that, if such an agreement is such an agreement required pursuant to the Sunshine Ordinance. So it's regarding that agreement, and does it exist, and is it required?
Okay, clear?
Clearer.
Okay. Member Josh Wolf, Chair of VOT, do you have anything else to add to give us some background on this?
I mean, those two questions, both for the library and to the city attorney in terms of the legality, really was what prevented us from being able to move forward with making a recommendation.
Okay, great. Okay, let's hear from the parties. Petitioner first, 5 minutes.
Okay, just so we're very clear on the basis, Ray Hart's Director, San Francisco Open Government, clear on the basis of the complaint. On page 528 of your packet, it says City Librarian Luis Herrera, City Department Head, has allowed to be collected funds for the purpose of carrying out or assisting any city functions without putting in place an agreement in writing to abide by this ordinance.
Monitors on.
Here's the section in question, and the underlined point is the whole basis of my case. When such funds are provided or managed by an entity and not by an individual, that entity must agree in writing to abide by this ordinance. And I have made requests of the library for any evidence that they would have that says that there is an agreement between the Friends and the library. They raise millions of dollars a year that is in the name of the library, and there is no agreement as far as I can see, and the ordinance clearly requires that. I'm not really going to make it any more complicated than that. What I would like to ask you to do is find the public library in violation of this ordinance, because there is no written document in place requiring them to abide by the Sunshine Ordinance. I would ask you in that finding to order them to comply to get such a document in place. Have it directed to the Compliance and Amendments Committee to have them show up and say, here's the document, it's all signed, sealed, and delivered. And if they fail to do that, send it back to the Full Sunshine Task Force for recommendation to find a willful violation. If you look at the response from the complainant on page 533 of your packet, it just gives, it doesn't say there is or isn't a written agreement in place. In fact, I think it sort of intimates that there isn't, because it says, to the extent the complaint alleges the library has allowed a separate entity to collect funds for donation to the library without an agreement that entity to abide by section 6729.6, the library is reviewing this requirement and will comply if it is not already in compliance. I think that's sort of a tacit admission. They're not in compliance, and saying that they're going to be in compliance. But the bottom line is this entity has been raising money literally for 18 years, and they have been then therefore not complying with this law for that length of time. I have raised this, and several members asked me, you're always after the Friends. Well, if they had complied with this, I wouldn't have had to bring many of the cases I brought. Bottom line is we have a group out there of private individuals appointed by no one, reporting to no one, and as of this month, it has been 4 years since the Friends of the Foundation of the Friends and Foundation of the San Francisco Public Library has reported to the Library Commission any financial information whatsoever. They don't even show up anymore. And the bottom line is, as they were coming for years showing documents which I showed to be untrue, they then started not coming. And the bottom line is, we also had another case where I was denied use of the audiovisual equipment because it's only invited people, and someone on the task force said to them, well, would you invite Mr. Hartz or Mr. Warfield? And they said no. So basically it became then, okay, now if the Friends come, they can't even use the audiovisual equipment. Bottom line is, they have raised, as far as I can guess from what numbers are available, since 2000, had $80 million pass through their hands. There is no agreement in place where they are responsible for reporting to anyone what that money, what they do with that money. And here you can see clearly in the law that it says if you raise money in the name of an institution like the library, you're required to have in place an agreement to abide by the Sunshine Ordinance, and they do not.
Are there any persons or witnesses on behalf of the petitioner to provide any additional facts or evidence? On behalf of the petitioner, okay. Respondent, you have 5 minutes.
Good evening, task force members. Maureen Singleton, Chief Financial Officer with the library. I wanted to provide a little bit of background information about the library's general reporting on grants or on gifts, as well as specific to the Friends, and then an update on what's going on with our agreements with the Friend. The library does on its website disclose its gifts that it receives. It's found under the About Library, Library Administration, Gifts and Donation sections. It does list out all of the donations that are received. We also submit an annual report to the Board of Supervisors with the small dollar amount donations. On that website is a high-level report of all of the monies received from the Friends, whether in kind or cash, and that is done after a year-end reconciliation effort with the Friends and Foundation of the library. In addition, on an annual basis, the library does an accept and expend for the grants and gifts that we receive on an annual basis. And in the past, we've had an agreement with the Friends called a framework for the Branch Library Improvement Program that had in place reference to compliance with city rules and regulations. Currently, we are in the process with our city attorney as well as the Friends on working on a new MOU to replace the Branch Library Improvement Program framework agreement. With me today are the library's commission secretary as well as some representatives from the Friends, should you have any questions. Thank you.
Are there any persons or witnesses to provide any additional facts or evidence on behalf of the respondent?
Good evening, task force members. My name is David Strang-Calvert. I'm a member of the board of the Friends and Foundation of the San Francisco City Library, and for the last 2 months, I've had the pleasure of being chair of that board. The Friends is an independent, member-supported organization that is a bunch of really enthusiastic library lovers. Not only do we raise funds to support the mission of the City Library, we also advocate for the world-class library service we enjoy in the city, and we also run many of our own programs, mainly in the area of literacy. The Friends takes its responsibility as a fiduciary and a charity very, very seriously. We have a professional staff. We have a very experienced board. We have an independent auditor who reports to an audit committee. We make our audited financial statements available on the web. We make our Form 990 available on the web. We make our annual report of operations available on our website. For this, we have received a 4-star rating out of 4 for accountability and transparency from Charity Navigator. This is based on a 96 out of 100 underlying score. The only 4 points we're missing are for not having a donor privacy policy on our website. The donor privacy, though, and many of these other issues, these are trumped by the Sunshine Ordinance. And the Friends recognizes that we are obliged to comply with the Sunshine Ordinance. For the last year, we've been negotiating a memorandum of understanding with the City Library. It's currently under review in the City Attorney's Office. Every draft of this document has included a statement that the Friends will comply with the Sunshine Ordinance, and we are committed to do so. The rest of the Memorandum of Understanding memorializes all of the exciting parts of our relationship with the City, and we certainly hope that when this document is finished, we will resolve this particular issue and we can enjoy another 50 years of continuing to support the City Library. So thank you all for your time and thank you for your service on the Sunshine Task Force.
Thank you. Okay, members. He was, yeah. There's nobody else in the room. Okay. Member Canada.
I have a question for the respondents. So I just heard the gentleman say that this memorandum of understanding is in the works and has been in the works.
Mm-hmm.
Does that mean that there's no agreement current today?
Correct.
Okay.
Yes.
Thank you.
Mm-hmm.
Anybody else? Member Moss and Member Josh Wolf.
I would just find it helpful if I could see what one of these agreements would look like from a different department, but I don't know exactly how to go about finding one of those.
Probably have to make a inquiry with the city administrator.
Probably.
To the chair.
Hold on. Member Josh Wolf.
So the previous question was whether there was an agreement as in the MOU.
Mm-hmm.
Is there an agreement between you and the Friends, which I guess might be maintained by the Friends and not you, to follow the Sunshine Ordinance? It was just stated verbally a minute ago, but is there a written document that establishes that?
There's currently not one in place because we are in the process of drafting that MOU.
So was there a previous MOU?
There was what was called a framework agreement specifically for the branch library improvement program. And prior to that, I believe there was an MOU that was drafted around 2000. This predates me, and I couldn't tell from the documents that I was able to pull up if this were finalized.
All right, great, thank you.
Mm-hmm.
Chair Wolf, I have some questions too.
Hold on a second. We have Vice Chair Hyland and then Member Fisher.
And how long has the current MOU been in the works?
It's been in the works for a year. It has taken longer than anticipated.
Thank you.
Mm-hmm.
Member Fisher.
Yeah, I'm sort of
Hold on.
I'm a little unsure of this because, I mean, I'm very familiar with the branch improvement. Thank you, Bernal Heights Library. It's beautiful. I mean, I've sat on a lot of boards, and this is a pretty basic thing. You have $80 million coming through. I guess my question is, your speaker talked, you've been doing this for 18 years, and Mr. Hartz, are you there? I can't see you. Where have you been for 18 years that you didn't bring this up sooner? And, I mean, come on, it's been going on this long. So I'm just going to, I've sort of buried the lead. I'm just going to fast forward to the end here. This is probably a violation. But as we've heard from several people here, that you're putting this new agreement together, so I don't think anything that we're going to do is going to, make anything special happen or improve it in any way. You've already committed to fixing this and making this understanding, and maybe we can all thank Mr. Hartz for bringing this to light, so to speak. But I mean, am I missing something here? Like, well, this has been going on for a long time and nobody caught this? Because I know that, I mean, I get a $25 gift certificate and I have to, write it down. I'm sort of asking the world here. You have not.
Well, I mean, as I said, we did have the branch library framework agreement in place, and the full dollar amounts that were received were reported. As to the donor information behind that from the Friends, that information was not reported.
Okay.
And I think under the MOU that's being drafted, then we would be working with the Friends on compliance with that requirement.
So if I make a donation to the Friends, I kind of like the idea of the donor anonymous or whatever, not revealing that. I mean, I could see, maybe I'm reading this wrong, but isn't the idea here that you, the Friends, or sorry, the Friends, have to disclose to the city and anybody else that wants to know how much money is coming in? I'm fine with that, but now you're saying that you're going to disclose the source of all those funds? Is that?
It's what the ordinance requires.
Yeah,
Okay.
it's with the ordinance.
Oh, there goes my donation. Okay, thanks.
Yeah, and
If you spent $99, then they wouldn't have
I'm
to
well
do it.
aware of the $99 deal.
So, Chair, I had a quick question for the speaker.
Hold on, we have Member Eldon.
I'm good.
I just wanted to see the point on the website where there's disclosure. In your original presentation, was it on the About tab?
Yeah, it's about library administration and then gifts and donations. And then under that, there's a breakout of information by fiscal year. And you'll see a table that lists information on 801 forms, and then also individual donors. And then there's a summary report for the information that comes from the Friends.
Thank you.
Member Eldon.
Yeah, I guess I'm.
Here.
My understanding is that this sort of debate about how you describe your relationship has been a focus of Ray Hart's and other people for some time. I wasn't on this committee before a couple of years ago, but I mean, just to answer your question, my understanding is that there did need to be more transparency, and it has been an issue, and it's just taken a while to actually manifest. Is that correct? I mean, how would you describe the process of satisfying the relationship disclosure requirements? To put it another way, it wasn't a surprise that just recently you had to put this together. It's taken a long time to put together.
Right. Well, for a long time, the library has on our website reported the gift information. We also do link to the Friends website for their financial reporting as well as their 990. So that's not anything new. And again, we did have that branch library improvement framework agreement in place. And then this effort to come up with a new MOU has been ongoing. And as I was starting to say earlier, has taken a little bit longer than anticipated, but some of that had to do with staffing turnover in my office where I was short-staffed. And so this became a back burner project for me because I had direct pressing accounting deadlines.
Okay.
Yeah.
So, Ms. Singleton, I have a couple of questions. Did you have something else?
No.
Okay. I have a couple of questions. So first, in the framework, was there any language speaking to the Sunshine Ordinance, to the...
I don't have that memorized, and I didn't bring that document with me, but it's my understanding that it would have had a reference to compliance with city requirements. But
specifically, I mean, here it's talking about a specific agreement to abide by the ordinance, so that would be specifically noted, and very specifically, not just comply with all city requirements. I think that's a little vague with regards to the Sunshine Ordinance. But here we're looking at a specific agreement.
Right. So again, I don't have
You
that
don't have it?
document with me.
Okay.
I don't have it memorized, but we
Okay.
can provide that information to
Okay.
you.
So I appreciate the revealing of the donor and that part. But here, the specific area that the petitioner, Mr. Hartz, is noting is around the section of the agreement to abide by the ordinance. And it's just not this particular section. It's the entire ordinance.
Yes, I'm aware of that.
Okay.
And in the draft MOU, it does talk about compliance with the Sunshine Task Force
Okay,
ordinance.
so that means that the Friends of the San Francisco Public Library would have to have its meetings operated according to the ordinance. It would be open to direct access for requests and have to comply with the ordinance. Are you aware of all the aspects? You must be aware of the ordinance and its aspects to the library.
Right.
The same would then apply.
I would want to consult with our city attorney on that. My understanding in the original discussion with our city attorney on this topic was with respect to revealing of the donor information, and not that their meetings would be conducted, if I'm understanding you correctly, in a public setting such as this.
Well, the ordinance is pretty clear. It doesn't say must agree in writing to abide by this section. It says to abide by the ordinance, which is general for the entire thing. So I think we'll have our own consultation with our own legal counsel about that. I don't think this is an appropriate time to have that, because I'm inclined to refer this to compliance amendments, and those further discussions can be brought up there at that time if the task force so chooses to find a violation. Okay, anything else, folks? No more questions, clarifications, anything? Vice Chair Hyland, look like you want to say something.
I was going to propose a motion, but I'll wait till rebuttals.
Okay. You can stay there if you have a rebuttal. You have 3 minutes for any rebuttal.
No rebuttal at this
Okay.
time.
Thank you. Petitioner, 3 minutes rebuttal.
Ray Hartz, Director, San Francisco Open Government. It's kind of interesting they will bring up the framework. No, it specifically does not have any mention of the Sunshine Ordinance in it. I can tell you because I've read that for, I'd say, at least 100 times, and that's not exaggerating. There is a part of that ordinance that says at a minimum they will report on a quarterly basis the amount of money raised, the amount of money expended, and so forth to the library. And my request to the library, which was dragged out for 2 years for that information, was dragged out specifically because Luis Herrera, the city librarian, did not want to acknowledge that they had never reported any of that money. And that was a laughably minimum requirement in the framework, and they had never complied with it at all, and the library had not asked them to comply. So basically, the framework, if they're kind of putting that up as something that's supposed to say, well, we were following the ordinance, no, it isn't. Because the bottom line is they were supposed to report on the money raised for the library, the branch library improvement plan on a regular basis, and they failed to do so in any of the years that program was running. And I think what you're hearing here is, oh yeah, we're getting this in place. And you can ask Ms. Singleton whether this might not be true. There was money passing back and forth between employees of the library and the Friends that was not accounted for by anybody in the library. And when I started pressing them and requesting information, I said, well, how does the money get by? Is it like a magic shoebox where if I go and I expend money and then I want to be reimbursed, I put it in the box and come back a few days later and voila, there's the money? And they've insisted over the years there's never any communications relating to finances between us, how the money gets back and forth, who is actually responsible for ensuring that what was claimed as being paid for was actually paid for. All of those got very vague answers. And bottom line is they have never complied with the Sunshine Ordinance. and they put up what they wanted to put out. And the gentleman from the Friends said, well, we got a 4-star rating from the Charity Navigator website, which is a self-reporting website. They basically go on whatever information you give them, and for years, they couldn't even get rated because they didn't give them audited financial statements or tax information, and as a result, the Friends would give them blanks for those. And only over the last few years have they started to do that and gotten their 4-star rating. And they may want to disclaim it, but a lot of the changes that they have made, I think, are a result of me pressing this issue over and over and over again. Had they been in compliance all the time, we wouldn't have had all these complaints.
Okay, members, motion?
I'd like to find a violation or put a motion. And before I propose a motion, I'll say that in the years I've been on this task force, we've heard a lot of questions and, coming at this question in different shapes and forms. And I think I'd like to applaud Mr. Hartz for finding something in the 6725 that actually addresses it head on. And I think if we find a violation, have an order of determination, we can send it to whatever committee, but that at least light a fire under this organization to get that, that MOA, MOU out, and or, something that satisfies this provision. So the motion is to find a violation of 6726. 29-6. Thank you.
Is there a second?
Second.
Moved by Vice Chair Highland, second by Member Kanata. Public comment. Seeing no public comment is closed. Members, any other comments, clarifications? Member Josh Wolf.
I feel like we're missing an additional violation in that Ray Hartz sent a letter asking for this in writing and wasn't told exactly that they didn't have it, but was basically given this response. So there's also a request that didn't go through too.
Want to make an amendment?
Sure, I'll make an amendment. Does anyone have handy which section that would relate to? Yeah, and it's probably a lack of response.
So, well, the question is this is an IDR, right? So,
was there timeliness? I don't think so, right?
I believe this was an IDR because I thought
I don't see an
scrolling through
IDR in my
here-
packet.
You didn't see that? Maybe it was for the last one. It was. You're right. It's not an IDR. Yeah, it would be a general. Hold on, let me just see his. What page is the original request?
I'm looking for that right now. It was in
I
our.
don't have that in my packet.
So I'll amend the motion to include
Hold on.
6721B. I think that's the right one.
I don't see that. Well, first of all, I don't see an original request from the petitioner to the library requesting any information. So this is just a straight violation for this particular section.
Yeah, it's more of a statement than a request, isn't it?
I'm pulling up the EOTC agenda item to see because I feel like there was something much clearer in that.
Yeah, I don't see anything in this packet. So if there's something else, I mean, I don't, I'm not seeing.
Okay, I'll go back to my original motion, which I think is the crux of
Let's
this
just
anyway.
hold it there. Let's figure, if there's something to add, then we'll let the maker of the amendment do that.
I am the maker.
Of the amendment.
Okay. Don't I have to amend the original?
No,
Okay.
we'll vote to amend.
Got it.
Can I make a comment on the amendment?
There's no amendment on the floor yet.
Well, she can make a comment, though, right?
I mean, I wouldn't feel, if it's not in the packet, I haven't had a chance to look at it, so I don't feel comfortable with that kind of amendment. It might be in the original packet from the EOTC committee, but that isn't the packet that I reviewed, and so other people can vote on it, but I'm not going to vote for it because I didn't inspect it, so.
So I'm currently looking for it in the packet, but I'm curious in the EOTC packet, and I totally understand where you're coming from, but I'm curious if it is in the EOTC packet, why it wouldn't have ended up in the...
I do not make any changes between EOTC and the full task force. I include all documents in the packet.
Do you want, okay, Mr. Hartz, you want to add something to this?
My whole purpose here was to focus on the requirement that they have an agreement in writing to abide by the Sunshine Ordinance, and anything else, I think at this point would become a distraction. So I would appreciate it if we would just stick with the basis of the original complaint.
Fine by me.
Okay, great. Okay, so it's been moved by Vice Chair Highland, seconded by Member Kanata for finding violation of 6729-6, and I will refer it to Compliance and Amendments. Member Kanata.
So when it comes to compliance and amendments, are we looking for a legal document from them?
You're looking for the agreement, okay? And I think what that agreement should look like, I think if DCA COLA can help in maybe finding an example or maybe some language we should, but no, this would be an agreement, not an MOU. It doesn't have to be an MOU. It just has to be an agreement to abide by the Sunshine Ordinance. That's all this section regards.
Satisfying
6729-6. Okay. So if you could just help language that we're supposed to look for, that kind of thing, that would be helpful.
Thank you.
Okay.
Through the chair.
Yeah.
To be honest, I think that's between. It's sort of outside of our purview. I mean, if there's an issue with the MOU or whatever sort of agreement that they have, it could come back to us. But if they want to consult with us regarding what language they want to put in there, that's their prerogative. But they should really be consulting with their own advice council on that, and they could potentially claim that they don't want to disclose whatever draft memoranda it is to us as well,
Yeah, I'm not interested in us providing them with certain language for it. All I'm saying is that we're just for the purpose of the compliance and amendments, if they receive a document, if you could provide some advice to them as to what might it say, or give an example of what they should be looking for.
To our committee, right? Not
not to help them,
not
but
them,
just what,
us.
just to help the committee know that they so they can make a determination whether it's in compliance or not.
Okay,
that's all. Yeah, we're not trying to make this more complicated. Administrator, yeah.
Just to clarify, the violations for 67.29-6 for failure to have the agreement?
Right.
Written agreement?
Yeah, for failure, you can take it, you can even just quote the third sentence, the second sentence?
Yes, I just wanted to be sure that was the portion we were.
Yeah, that's the portion.
And it is going to be recommended that the matter be referred to the Compliance and Amendments Committee with a request that the library provide a copy of agreement that satisfies 67.29-6.
Yep. That's right. Correct.
And probably help to give them an idea of when that date might be.
What? Oh, the date of the committee?
Next committee meeting.
No, because it won't be agendized for the next CAC. That's already been done.
It'd be approximately 2 months.
Right.
In May.
Right.
2 months.
Okay. All right.
There two? There's two violations.
Public comment. No public. Okay, let's go for a vote.
On the motion, Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Barnetsky. Absent. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes, and the matter will be referred to the Compliance Amendments Committee.
Very good, thank you. Okay.
Would we like to go back to the item number 11, review of the complaint procedures?
Yeah, so we've passed the portion for, approved the portion for requiring attendance at the committee level. Now we're discussing at the task force level. Vice Chair Hyland.
Propose a motion that the respondent be required at the task force level.
So moved by Vice Chair Hyland, second by Member Hinsey. Discussion. Member Josh Wolf.
I mean, I feel like a broken record, but I still think that it's important to have the respondent or staff member at the full task force, and I'd rather.
That's what I just said.
I'm sorry, I thought you said complainant.
No, I said respondent.
Then I just apologize.
Okay, so I have a question. So what happens if they don't show up to one or the other? Then what?
Weren't we discussing language that would say that if you don't show up, the task force can adjudicate this issue without you?
Yeah, that's fine. I'm just saying that the purpose of doing one and not the other is more of a likelihood that they will show up, but requiring them to show up to both, in my history, has been the cause of the big problems in years past, in the 2005 to 2012, 7 years. There was a requirement they would come to both, and that was a big issue. I mean, that's what kind of gave the task force kind of a bad name, because they would spend so much time, and then they would have to sit around, and they would have to sit around for two different meetings. That was the biggest issue. That's why I was suggesting that maybe be one and not the other, and that way, if it could be adjudicated without them being at one, not the other, then that's the deal. Okay, Vice Chair Hyland and Vice.
Just curious, so was that memorialized back in your day in the task force?
It was, and I believe over the years maybe the process has changed.
So is that still somewhere in our books, and we don't need to be doing
I think
all this?
it's been amended since then. I think the complaint process has been amended since then.
I see.
And it's been amended several times. Josh Wolf.
I think this is a really tricky matter, because in the cases like Vice Chair Hyland brought up, where the respondent is already in agreement that there's a violation, and they're basically showing up just because they feel that they need to, even though their response is basically, yeah, everything that he said, it's all blah, blah, blah. Like, it's stupid to make them come in those cases. But when there is a situation where the complaint committee isn't necessarily on the same page amongst the whole committee, and there's all these different parts that require insights from the city attorney and this sort of thing, then not having them is a real problem. And at one point, when we reintroduced the complaint committee about 3 years ago, the issue of whether the complaint committee whether this group was actually as a de novo to review the whole case, or basically signing off or rejecting the complaint committee's recommendation. At the point that they're not there, we sort of are put in the position of signing off or rejecting the complaint committee's recommendation.
Member Tesfaye.
I disagree, because as it's been emphasized before, the complaint committee would only be on a fact-finding journey. during the committee meeting, and that's why those individuals need to be present. Any kind of legal recommendation or argument on the legal issues, which can be done in writing, would not be occurring at the complaint committee hearing. It would be to be finding the facts based around the violations that have been specified by the petitioner. And so that's why I don't think that the respondent should necessarily have to appear before the full task force. They still have the opportunity to appear, and that language can be placed there that if you don't appear, an order can be found against you, whether you appear or not appear. But if it's at the complaint committee level and facts still need to be found, then we would just continue the item and direct the individuals who are present to provide the additional facts that need to exist in order to support whatever specific violations have been identified by the petitioner.
Vice Chair Highland.
Just to summarize and agreeing with Member Tesfaye, I think because now we're seeing a much more efficient complaints committee in action, probably the way it should have been all along, I think it's really going to streamline things. On top of that, our administrator typically groups task force meetings with 3 cases pertinent to that one department. So they're going to be here anyway. I mean, that's kind of, we're kind of getting efficiencies there. The other thing I'd ask you guys to think about is we have language for the complainant that if they do not show at the original committee meeting with no notice, no email, whatnot, I think there's provisions in there where their case will eventually disappear if they continue going that route. And the balancing side is for the respondent, if they don't appear at the full task force meeting or other subcommittee meetings, we will rule in their absence. I think that's a nice balance. I think that's fair, and I think that will, I think if you look at that as a complete policy, I think that's a good one. So I think let's give this a go for 4 months, 6 months. Yeah, the chair can always bring it back for us to revisit. If department heads get in touch with us and say this is arduous, we can't do it, then we have this discussion again.
I'll just say that I've met with several department heads, not commissioners, not yet. They're coming, but department heads to ask them about stuff and have flatly just said, open door policy. Here's my number. Email me, call me. You got any issues that are coming up? Let me know, because I want to make sure that they show up, okay, and that they don't, thumb their noses at us, because that did happen for many, many years in my previous tenure. So, that's what I'm looking at from that perspective, and I think for the past several years that I've not been on a task force, there has been I'm not quite sure what the experience is, but I think over the past 6-8 months that I've been here, they've been pretty compliant in coming. So I think that's kind of my thrust here is trying to make sure that they continue to come and they don't see us as being a hindrance, and that they see that Sunshine's important. It's got to be done, especially now with what we're dealing with in this country. I think it's incumbent that we all put on, if not just a good face, but we really kind of pull it together and make sure that transparency is in front and center and important. So that's it. All right. Any final words on this? Let's get some public comment.
Ray Arts Director, San Francisco Open Government. I agree. I believe that this motion is a good one. My real belief from experience is that if you have the complaints committee and both parties show up and you get the issues kind of winnowed out to the point where everybody kind of understands what the specific matters are and any other information that needs to be provided, I think it's very likely from my own experience that if the complaints committee forwards it to the full task force with a recommendation to find violation, there will be a very strong likelihood that the respondent will show up, hoping that at that point they can cut it off at the pass. But, it is it was like, I'm going to use the previous item as an example. The library at any point could have simply said, no, there is no written agreement in place. But they just don't do that. They come in and they do a song and dance about, well, we're in the process, how long it's been a year, and how long we've been raising money, 18 years, and, it just goes around in circles. There are very, very few cases where someone actually just comes out and says, yes, we were wrong, we didn't comply, we're sorry, end of story. Most of them, it's going to be just going around in circles, and that's what I think the Complaints Committee has gotten very, very good at, which is tying people down and kind of saying, let's stick a pin in it here, and yes or no, did you or did you not have an agreement? No. Or, but then they will still try to equivocate and go, well, never wanting to actually admit. But I believe that as long as the complainant and the respondent both show up at the complaints committee, the likelihood is, especially if they pass it to the full task force with a recommendation to find a violation, I believe the respondents, and I know from my own experience, the complainants in most cases will both show up.
Okay.
Just for my own clarification, the motion was to require that the respondents are required to attend the full task force meeting?
No.
It was not.
Not required, but that in the instructions that you send them, that it would state that that it could be adjudicated without their presence, and that it's at their discretion.
It's their discretion to appear. However, if they do not appear, it would be adjudicated based on
the facts that were brought forward.
That wasn't actually my motion. No. And I can amend that, but
Okay.
I thought the motion that I made was that, we've already got the first motion on the way, that respondents are required to appear at the full task force meetings.
Oh, my apologies. Okay.
And then we had discussion which...
Okay. So then you are opposed to that?
Yeah, I'm opposed to that.
Oh, okay.
I am concerned that Mr. Hartz's comments were, I don't know what motion he was speaking to, because it sounded like he agreed with me, but then...
Okay.
Right.
All right. So,
I think
where
The
are we
original
on this?
motion by Vice Chair Hyland was to require the respondent to attend the meeting.
Okay.
And then there was discussion regarding...
task force meeting.
The full task force meeting,
Okay.
yes.
And my comments were against that.
your comment was against.
Yeah, I'm
Okay.
against that,
Okay.
too.
My mistake. Okay.
So wait, we're having them required to be at both? Because that's not
We've
the
already had a
direction we were
vote
going.
on the first two, and we've already passed that they both have to be at the subcommittee.
Right, that I get.
Now we're going to vote on whether the respondent is also required to be at the full task force meeting.
I'll vote away, but I'm voting no, so factor your numbers in there.
Thank you for paying attention. All right.
Okay. Any other comments, clarifications? Everybody understands the motion? Okay. Vote. Call the roll.
On the motion, Member Hensy. Aye. Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Barnetsky, absent. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa.
No.
Tesfa, no. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Doesn't matter anymore. No.
Fisher, no. Chair Wolf.
No.
Wolf, no. The motion passes.
Okay. Okay, so adjust the communications accordingly.
Yes.
And then we'll revisit this in 4 to 6 months and see how it's going.
I can already tell you how it's going to go.
Okay.
Yes. And just in regards to this, I have a separate concern regarding, because of the short notice that I'm giving some of the members of the public, of both the respondent and the complainant for the initial meeting at times.
You mean the complaint? At the
Yes.
complaint level?
At the complaint level. Sometimes I'm giving them 1 week notice because I'm trying to get it onto the agenda in order to hear it quickly.
Yeah.
There are many times where their respondents have prearranged meetings and they can't send someone. And I was just wondering about those circumstances where the respondent just can't send anybody.
Well, here's the thing. The complaint committee's primary, if it's a 6721 or 6725, got to be heard within 45 days.
Yes.
With or without the parties there. Okay? And notification.
And we'll leave it up to the committee.
Has to be given to the complainant, to the petitioner.
Okay.
Okay? So that's first and foremost. Okay? If they cannot make it, I think it's up to the chairs of the committee to determine whether they want to continue the item or not, and to control their own agendas at that point, okay, beyond the work that you and I do on assignments.
Thank you.
Okay. Member Josh Wolf.
So this point ceases to have much relevance without Member Kanata here, but he's the chair of the one that's only, 12 days away?
I will be sending them a notice changing the requirement that they must appear.
So I guess the question is, do you and or Kenyatta have a plan for if they, because they were told they didn't need to appear, if they now say they can't appear, do you want to just reschedule that item for them, or what? How do you want to deal with that?
I think I'll give the latitude to the chair of the Compliance and Amendments Committee to figure that out.
Absolutely. It was weird with him not being here.
I know. Well, we can wait for him for
That's one of the
moment.
reasons I asked that question.
Yeah, no problem. So, Member Kanata, as chair of CNA, you're the very next meeting that's coming up, and so since we just passed this, notifying the parties that they must appear, if there's any concerns or maybe the respondent can't make it, I'm going to leave it up to the chairs of the committees to deal with that. Whether you want to continue the item or reschedule it, you can work with Victor, our administrator, to figure all that out.
Okay.
Okay? Great. I don't want to micromanage, so. All right, next. So it's 7 o'clock. We don't have to go all the way to 9, but let's see if we can get through maybe one other on this list. Which ones have we done already?
Everything here is brand new. I removed items that we've already
removed
done.
the other item. Okay. Okay, so let's talk about the second bullet. This is a long-standing issue that I've had because the task force, from term to term, even from year to year, sometimes you don't remember, and sometimes the cases aren't reviewed that are archived or very old, of decisions that have been made. They're kind of part and parcel, or kind of repetitious, that are very clean cut. And so if we had some sort of precedent and log of the task force decisions, it would help us. I've asked DCA Cola to try to find previous cases to include in his advisories to us that might help us easily and easier come to decisions. So if cases are very complex, but there's been a similar case with a similar outcome, it makes it easier for you to understand what the result could or would be, positive or negative. So part of this is how to do that. And we've discussed in the past of maybe forming a little tech committee, maybe to try to create some sort of database that's searchable in some kind of way. I don't want to get into the details of that, but there are now a number of how should I say, like coders in residence that the city has been nursing through the Department of the Mayor's Office of Innovation that has actually produced some interesting results in various departments that have very large database problems. I know that, who was the last one I just spoke to about that? I can't remember, but there was one that we had assessor's office. The assessor's office is huge overhaul, and that's the information that comes out of there is just astounding. So I think we can join in on that. We can make a request to have somebody consult with us if we wanted to, or we can identify what our needs are first and then put together some sort of like an RFP, a mock RFP or quasi RFP or some sort of request for a proposal. But I think this is important because we don't actually even have a binder that you can go through that's kind of has some sort of taxonomy or cataloging that would help you find that. Member Josh Wolf.
I mean, I think it sounds like a great idea. At the same time, it seems like the technical hurdles to build this database are much less than the analysis of the actual decisions and figuring out the taxonomy and how to break them down and sort them, which is probably something that's going to be much harder to find outside assistance on than the actual database. Like, I'm not sure that we couldn't, build something with like a simple web database tool that's for non-tech people in a matter of hours. But other than like identifying which section of the Sunshine Ordinance the violations were, which is fairly easy to do and sort, it becomes a much more complicated process of breaking apart all of the different sort of circumstances that are differentiatable.
So let me offer you this. This idea kind of came to me when I had to go to the rent board. And they used to have the old candy apple IMAX, the original IMAX sitting up there. And they would have a list of every single report, violation, claim that was publicly available and searchable. And I found that to be very interesting because at any time, a tenant or a landlord could come in and do a search to see if there was some ruling on an issue that was already had been adjudicated by the rent board or a hearing officer. So I think we're kind of in that same kind of boat. And talk about variety of issues and complaints. I don't think you can get much more than that from the rent board. And they have a very pretty clear-cut, set of guidelines, codes with regards to what can and cannot be done by one or the other parties. So, but I think it's worth the discussion to at least approach it and see if we can pull together some semblance of a taxonomy or search filtering or some sort of cataloging or something like that. It may not be something that we finish in a year. It may take longer, but if we can at least pull something together, we might be able to get some help from the city, maybe even to get a consultant to actually help us with the taxonomy part. Maybe somebody's done it before. I don't know. They have some script that they can, pull together that captures like semantic search in a way. Where it's looking for a variety of phrases or a variety of possible ideas, some AI of some sort. But I think it's important at this point, and we're going on a very long time with the task force. I've seen many decisions come out of the task force over the year that were counteracting each other. They were in conflict with each other, right? And it makes it difficult because then if we find them, then we have to kind of come up with a brand new answer for that being that way. So, yeah.
I think in terms of budgeting for how much this is going to cost, the biggest issue is how far back we want to log, whether we want to go back all the way to the original passage of the task force or the last 5 years or what. I think that's going to drive how big of a project it is.
Right. So I think that's worthwhile discussion for a small committee, a group of us to get together and talk about. And I would say I would ask for volunteers for that. I think we should have one meeting and then see, try to see how many times we want to meet. We could invite Jay Nath to come and talk to us about what is available in this area, because that's his bailiwick right now is public data, and that's what this kind of is. So, and the other thing is also DCA COLA. I know that in the city attorney's office, I had this discussion with DCA Threet, and the answer I got was, well, all of your cases are kind of mixed in with our own database, and that's not publicly available per se. There wasn't a way to get a kind of a database dump of just our items. But if you already are using a system that we could replicate, we can actually find the same platform and then just take all our stuff and throw it in there, and it already has some of this filtering, these search functions that we're looking for. I think that would be helpful.
Through the chair, I mean, I'm no tech expert, but I mean, every memo that the city attorney's office has ever written is in a PDF format that we give to Victor, and I think all of them going back, I don't know how many years, is available on sfgov.org under the Sunshine website.
Okay.
If you could have somebody, if Sunshine finds it in their budget to find somebody that could, what do you call it, OCR it? And then you can make it searchable.
Yeah, it's not so much that. It's the actual, when you look at, well, like in your office, when you look up, my dad was an attorney. He had one of the first big databases in his firm in New York. And I remember going through that and seeing they had created all these queries. And there was a query for every possible thing that they could find that was based upon cases that they had and case law that they had imported. So it's really kind of figuring out, like, if there's something already there, like in your office, we're not asking for the entire compilation of the city attorney's office. We're just looking at the small portion of Sunshine. But if the platform that you use would lend the same function as to what we're looking for here, just knowing what that platform is, and we can go buy it ourselves or build it ourselves or use the same kind of query system or something like that. That's all I'm asking. We certainly can fill the database with data. That's not a problem.
Yeah.
It's just the function of search is really the issue. So I can call your tech guy and ask them.
Cool.
Member Eldon and Member Tesfaye. Member Tesfaye first.
Does the city attorney use something other than Lexis and Westlaw? You guys have another database of cases? Okay.
That's it.
Because Lexis and Westlaw are, proprietary and expensive. But
right.
Are our cases in there? Sunshine Ordinance cases, decisions are in Lexis? Oh, okay.
Yeah, that's why I'm saying they got to have some other kind of system that collates it. So go ahead, Member Eldon.
I guess
microphone, please.
Something that's sort of, I think we need to resolve is it sounds like you're mostly talking about like how to structure a bunch of like case law versus like organizing metadata.
Right.
I mean that, the really basic things out there are like Google Site Creator, right? Like where it's like there's not like analysis that needs to be done. You don't need pivot tables. You don't need all of these other things.
Right.
You just need like a nice indexed.
Yeah, but a way for any of you that, can actually type in maybe even what we call regular expression. Just type in a phrase and say for a particular, you're reading over a case and you're saying a light bulb goes off. I want to know about this. Did the task force ever take a position on something like this? How do you create a search for that? In that kind of way. You could do regex, regular expression searches. You could do that, but the question then becomes: does it have to be exact? Could be fuzzy, that kind of thing. There's all those kind of technical aspects that go into something like that. But I think it might be helpful to kind of not only enrich what we're doing, and so we can learn about what the task force has precedent for, in year after year after year, but also help speed up our decisions, because then we don't, we could just say that this thing just points to that, task force already did it. Sounds like a bunny. Feels like a bunny. Must be a bunny. Okay, and that kind of thing. So open for volunteers. Member Josh Wolf, Member Eldon. Okay, so I'll put together a meeting and we'll figure out. It'll be ad hoc, an ad hoc meeting. We'll figure out a meeting time and a place. I'll send out just a note to everybody, and we'll take it from there. And then we'll figure out how many times we need to meet. We may not need to meet that many times. Okay, great. Can we take another one of these on this list? Which one?
The tabling for being unresponsive or non-appearance, maybe we should talk about that since we've just talked about having respondents and complainants have to come to meetings and stuff.
Okay. Let's do that. So tabling for being unresponsive or non-appearance. You want to start the ball rolling?
So, the word tabling. Now, if we're requiring, let's go to committee level, if we're requiring both parties to be there and they're not there, and the purpose of the committee, of hearing a complaint at the committee level is to gather all the facts, do we gather all the facts from one side and note that the other side wasn't there? And then does that come up to the full task force? I mean, how do people think that type of stuff should be handled?
Member Josh Wolf, and then Member Vice Chair Hyland.
I mean, there's also so far this hasn't happened quite this way, but someone files for a records request, an IDR, and it comes 2 days late. And so this is then it's through email, so there's timestamps. So someone can file a complaint and say this is when they wrote it, this is when they responded, do what you will, and not really feel like they need to defend that because it's
obvious.
It's hot, it's black and white. And I don't think we should automatically table it, particularly if, let's say they filed this complaint because this is an issue that they're concerned about, but they work, hours that they can never attend a meeting. I don't think we should automatically table things that we can proceed without them.
Okay. Vice Chair Hyland.
I agree with that, and I could see Mr. Hart standing up and saying exactly what Member Wolf pretty much did. I think the onus has to be somewhat more on the respondents, I think when we were going through this before it got to this format, I think what we were talking about was continuances, and correct me if I'm wrong here, Victor, but let's say a complainant files a complaint for the first time, asks Victor to move it, asks him to move it again, doesn't show up at the first meeting. I think that was what was more troubling to us than it was, a first-time complainant not being here on the first meeting. We should be able to take the baton and run with it for that person and talk to the respondent and package it, and hopefully they'll come to the next meeting. But I think it's more important. I'm okay with not even having that language in there, period, for the complainant not showing up. However, I would like some language in there for complainants, serial delayers, whatnot. You see what I'm getting at with this?
Yeah. Okay.
I was wondering if we can the question regarding continuance, not accepting continuance for an undetermined amount of time. If we can document the task force's position on that, that would be very helpful.
Indefinitely?
Yes.
Like that one, yeah.
Go ahead. Josh Wolf.
I mean, I like that, and what if we borrow some of the language that we were looking at for the respondents that's basically the chair may table your item for not showing up, so that it's there that we empower the chair to do that when it's a sort of repeat issue or all of these things, but we're also empowering the chair to move forward with cases where like either they chose not to come because they don't feel it's necessary or whatever.
Through the chair, I think better language might be the committee, task force, or chair may rule in your absence, which may include, tabling is confusing, but we can say tabling or closing your complaint. Just put it out there, something like that.
Anybody else? All right. Do we need to take any action on this? Do you want to memorialize it? How should it be worded?
What page are we on? Is this covered?
It's not on a specific.
It's not, okay.
Page.
All right.
Go ahead, Member Canada.
And I just think that if we have wording in everything we send out to the complainant and the respondent saying, explaining who's required to be there and stating that the committee or the full task force can act on these issues even if you're not there. Some type of appropriate wording like that so that if action is taken, if at the committee level we feel there's enough information there to pass it up, either side can't complain and say, but I wasn't there.
Through the chair, I think member testified is probably going to roll her eyes at this, and it may not be necessary, but just something along the lines of, this is your due diligence. We are encouraged to show up. If you don't, we may do X, Y, and Z. Same wording for the respondent.
Okay, so at the Rules Committee, if you look in the notes for this particular item, it says the Rules Committee discussed the practice task force to schedule complaints to be tabled or closed if the complainant is unresponsive to communications, and to table or close complaints for complainants who fail to attend the hearing without informing the task force.
That's already in there.
Does that cover kind of everybody's concerns or interests?
Leave some leeway, too.
That's on page 557. 557. What do you think?
Do we need to?
This only states complainant, right? So we would have to put respondent in there too?
Yeah, change it how you want. This is what we had discussed at the Rules Committee. But that's kind of the basis of the discussion for this. I think part of it was that we've had a number of complainants that have, continued items ad infinitum, and it kind of, messes up it causes a backlog. And if it was serial, that we wanted to have some way to communicate to the public, we're only going to stand for so much of it, and this is how much, or not at all, kind of thing.
I'd like to insert the word without adequately informing the task force.
At the end?
Well, yeah, towards the end. I mean, because some of these people, last second, they'll cancel it, and the departments are all showing up, and that's happened several times. So, I mean, we could put in 2-3 day notice, but adequately, I think we'll.
You want to formulate a motion?
So
Victor has some direction.
Sure. So this is the section.
You don't have to necessarily make the motion per se. We can talk about formulating a motion,
okay,
and then we can discuss what it should be, so we don't.
Okay. So this is a motion.
A lot of amendments.
Motion concerning unresponsive and non-appearance for complainants, and I think the task force should have should be able to close or table complaints if complainants are unresponsive to communications, period. Because we've already talked about attending the hearing part. Mm-hmm. So it's really they're just unresponsive means your case goes away. That's the summary. That's what I'm trying to get to.
Okay.
So just to restate that, task force may table or close cases if the complainant is consistently unresponsive. or just is unresponsive?
It still sounds a little vague to me. I think we want to. It's kind of.
You want like a one strike, two strike language?
Do you have a suggestion?
What about fails to show up without prior communication?
That could be read two ways, so we have to get better language than that.
How?
Fails to show up without telling you you're going to show up.
No, but that
I know what you're trying to say, but that language can go both ways.
I'm still confused on the two ways, but
okay. So
language is fine.
It's getting late. So that I think we've already moved past throwing out cases if the complainant doesn't show up, because we're going to carry that torch. I think we agreed on that, right? So we're not talking about no-show anymore. We're talking about them not being responsive to Victor, to us, to keeping the case going. Yeah. If they're not working with us, we can't work with them. That's the motion I'm making. That part only, not the no-show.
But how are we prepared to define what responsive means?
We can do that. We can say if the complainant is unresponsive by telephone, email, or you could put in a number, or didn't respond to the last 3 emails. I mean, we can quantify it if you want, if that makes it tighter. I was just going to leave it vague and just say is unresponsive to task force communications. That was language I was thinking of, just plain and simple.
I would add, so let's see. So the task force may table or close a case if the complainant is unresponsive by submitted communications and contact information they have provided. That's an important factor, because we just dealt with this at the Ethics Commission, where they reopened the case because the complainant was not sent the information at the right email address or the right thing. So,
task force may close the case if the complainant is unresponsive to communications mediums they provided.
Yeah. Okay. But then you got to go a little bit beyond that. That's just a disclaimer. So, is unresponsive under what conditions?
Consistently, I mean, or adequately?
Well, is it at what period of time? Is it from they submit a complaint, the administrator has issues correspondence, requests for dates that are available for people. There's all kinds of decisions that have to be made along the way. So unresponsive at what point? At what point do we want to consider tabling the item? Okay, Member Josh Wolf and Member Kanata.
I'm a little concerned about, if someone sends something off and then they go out of the country and they think that they're going to come back in 2 weeks, and they talk to Victor when they drop it off and he's like, oh, the next meeting's in 2 weeks or whatever, so they're not concerned. I think we need to be either really, really vague or really precise, and unless we're going the really vague route, I think someone needs to come up with language and bring it to the next meeting rather than trying to script this right here.
Okay. Member Kanata.
I was going to say, I think it should be unresponsive once the date of the first hearing has been scheduled. So I'm a complainant. I send in a complaint. Victor's communicating with me, and we set a hearing date.
And you don't show up.
And then either I don't show up is already covered. But if Victor needs more information and sends me an email or calls me, and I just blow it off, I don't do anything about it. I don't provide any information.
Well, what about if a petitioner sends in a complaint, petition for a hearing, Victor then communicates with him, doesn't hear back? How long should he wait until he informs me that, this is not happening?
How about this? How about 5 business days? If they've been, if the complainant has been unresponsive for 5 business days, the case may be tabled by the chair.
What do you think?
They could always reopen it. It's not the end of the world. But this
Well, tabling, let's be clear. Under Robert's rules, a big difference between postponement and tabling. If we table something today at this meeting, if it doesn't get taken back up in discussion, it dies at the end of the meeting.
Okay.
Okay.
So why don't you put the language in may table or postpone and give the chair that call?
Well, table is really not the correct word because that would be in a deliberative process.
Okay, I think table is confusing to the public anyway.
It would be closing. It would just be kind of, terminating.
All right, I'm going to take out the word tabling because I think it's confusing to the public. Because tabling sounds like it's on the table to be discussed. So maybe closed or continued at the chair's discretion.
Yeah, just waiving Robert's rules. Just speak up.
So let me restate that thing is if a complainant has been unresponsive for 5 business days or longer, or just 5 business days, the chair may close or postpone that case.
I think it should remain at closed. Otherwise, the postponement is.
Yeah, okay. It's semantics. The word to use is really semantical. We just need to find the right word. That's all. Terminate, close. There's a whole bunch of legal terms you can use.
I mean, I'm still a little worried about what happens when, someone. Well, 2 things. If we're making this the discretion of the chair, and we have someone who's a regular attender of our meetings, and it's well, why did you suspend mine and you didn't suspend this other person? I'm a little worried that I don't know whether that really should be the discretion of the chair. It seems like we should create some sort of a point where if you fail to meet these criterion, then it's closed. Then the chair can close it because it's too potential for sensitive people to think they're being ruled against given.
So how about this? If I change it to, if a complainant is unresponsive for 5 business days, the case will be closed. Boom. Dismissed. Closed or dismissed.
Would that? So I'm still on the difference between
member testifying has been
if
dismissed.
a case was scheduled or if a case wasn't scheduled. If somebody sends in a complaint and Victor sends an email out to this person saying, hey, we can hear your case on such a date and never hears back.
I don't think we need to get to that.
I don't ask. I just schedule.
Okay. So you schedule it and, okay,
They
fine.
can ask for a postponement. I believe this issue is going beyond the original intent. This is for people who had long-standing issues with the task force, and then they refused to respond when I tried to schedule because they would continue it multiple times. And then when I try to get them to talk to me so I can schedule it, they ignore me. And then in the past, I would take all their items, put it before the task force, and I would tell the task force, this person has not responded to me in so many days. Please table the complaints. And I would send out notices to everybody, including the complainant, saying that the task force is going to consider a motion to table all your items. And I would notify them of that. And if they want to show up and contest that, they could.
Yeah, so I think if we get through nothing else tonight, than just saying, being unresponsive for 5 business days will result in your case being closed. That's one. And then the second part is multiple postponements by the complainant. How do we handle that? Give you 1, give you 2 strikes, and then you're out. Again, that closes your case. That's the second part I want to get to. I think if we just handle those 2 things, it'll help Victor out a lot. So the first part, I guess, is a motion, yeah?
Yeah.
Okay.
If you want to try to formulate a motion, let's hear what possible language it could be. And then we can...
Okay. If the complainant is unresponsive to the task force for 5 business days, the complainant's case will be closed. Dismissed? That's the motion, yeah. Should I take a stab at the second part? Not yet. I think we have
Hold
to
on.
discuss it.
I don't want to make it a formal motion yet. I just want to make sure that we are wordsmithing and make sure that the crux, we're getting to the right.
Yeah, because to remember Cañada's point, it may not be a case yet if it hasn't been scheduled and it's not an item and all that. Your matter will be dismissed. Might be better wordsmithing.
We'll figure out the correct word, but the sentiment is that it should be closed or taken off the docket or removed from the agenda or something.
This
like
one
that.
would be very helpful for when I don't have enough information. When I receive a complaint, a lot of times I will not have enough information, and I'll send out a request for additional information. And this would be good in that if they don't respond to me within 5 days, I can just close it out.
Right.
They can always refile it.
Yeah, can I just raise a question or a scenario here? So let's say I'm a inmate of the San Francisco County jail system, and I do have a right to file sunshine requests, but my ability to respond within 5 days is dependent on the jail mail system and the custody that they have me in. Am I just going to routinely have my complaints thrown out, or is there something else to account for?
You can put a caveat that says, unless you're under remand or a ward of the state, you could.
We can increase the number of days if you like.
Yeah.
Prior explanation that you may be incommunicado.
Right.
Is established with the task force prior to.
So then on the complaint form, I think maybe an instruction on there to say, put this item in there, but then also put it will extend beyond the 5 days.
Yeah, but even still, if Victor is having to have communications with somebody by snail mail, 5 days is not appropriate time limit.
And I believe in those
you can't guarantee
situations
that he's going to mail something and get a response back through the postal system within 5 days.
I believe in those situations we use our best judgment and just work with it.
Yeah, I mean, you could put the scary language up there, but it's up to us whether we actually.
Do you want to give some discretion to Victor, to give him some latitude to be able to?
I think
kind of make it work, but the whole idea is good faith upon the petitioner.
Just to protect Victor, I think the discretion should be to the chair, and then you can tacitly give him that permission.
What do you think about that?
I mean, I think that it's important that we try to reach out through, like, if they put down a phone number, an email address, and a snail mail address, I kind of feel like we should probably try to reach out to them through all three communication methods they listed before we dispose of their case, which in many ways seems like more work than we should do. But if we're talking about building processes to dispose of their cases, I think it's really important that we recognize that they may have put all three of these down, but actually their snail mail is through, this nonprofit that they can't get their mail through, and really the phone is the only way to actually reach them. And I don't know whether we can make the form tailored to that response, but it just seems like avoiding dismissing cases when people aren't shining us on, and it's just a sort of breakdown of communications, is not the path we want to take.
Right. So I'll add back in, that they should be contacted through all communications and contact information, or communication channels and contact information submitted by the petitioner.
So, through Chair, is this going to go on the complaint form language?
I would hope not, and we can just do it via my communications to them.
If we're going to do it on the complaint form, I think the tone should be something like, please list your best medium of communication, preferably your best email address.
We do state you must provide at least one reliable means of communications.
Right.
And just to ease the tension, not to ease the concerns, this is not a common practice. This is more for people who are not filing complaints properly with the task force. They file complaints that have nothing to do with sunshine, However, I still have to respond in some manner. I ask for clarification. This does not appear to be a sunshine complaint. If it is, please tell me what your complaint is, and so forth. And most of those, I never get a response to, and I don't process them.
So what if we were to deal with, like, in many ways, it should be the Sunshine Task Force that's making the decision to extinguish these complaints and not our administrator.
That's a good word.
Right.
What's that?
That's a good word.
And so it seems to me that maybe as part of the administrator's report each month, Victor could basically provide a list of all the people that dropped off the planet, and then the task force, through a sort of lump motion, is like, we're just extinguishing all of these errant cases.
So you want to do a consent calendar item?
It would be a consent calendar at the bottom end, yeah.
But you have to be cautious because we have to make sure that we get to it. So, if sometimes our meetings run too long and then we are getting kicked out, then we'll never get to that item. So I would suggest, because it's a consent item, it's a very simple motion, and just do it at the top of the.
I mean, I don't care where we put it. I was just looking at the actual agenda.
Okay.
It could be right after the minutes.
Yeah, you do. I would say do it right after the minutes, and you just get. It's a very simple motion. Unless somebody wants it pulled, a complainant or a respondent can pull it. Request for it to be pulled, and then we can have a separate discussion. Or a task force member. Yeah, anybody can have it pulled.
I do currently list all the submissions on my administrator's report, and I usually do put a note, not accepted yet, pending receipt of additional information. And in regards to the other portion of that, for me to not accept that complaint, I'm going by the minimum requirements established by this task force at the last meeting.
Right.
I'm not creating any new rules. I'm going by the minimum requirement of what they have to give me in order to open a file.
Right, that's good. So the only thing we would be asking for at this point is to just collate those items that are, those petitions that are outstanding, that are unresponsive, and put them into a consent calendar item for us to dispense with them.
Yes, that's what we have done in the past. I would put it on the agenda for the task force to make a decision on.
Oh, okay.
Oh, in the administrator's report?
So we just did this, this whole.
Before it was ad hoc, I would just.
Oh, okay. Well,
I would do it to try to.
Okay.
I would ask the chair if it's okay for me to do this, and.
Okay. Well, then let's just make it so. Let's just memorialize it then. Simply.
I'll try to write something for the next meeting for your final approval.
Okay, that's great. All right, is there any other items that you want to dispense with on this list?
How about the second piece about serial postponers?
You mean the vexatious complainant respondents?
No,
No,
that's different.
Oh, okay.
Not getting
People
into
who
that one.
postpone month after month after month.
The serial postponers. Yeah, I think.
And again, this probably refers to just a few people that kind of rig the system to kind of. Yeah, I know I've seen the communications from Victor, so just to protect him and help him out in his job a little bit.
I mean, why don't we basically give them the equivalent of unresponsive status? Like, basically, we're creating a file of cases that Victor has deemed to be non-viable, and then a consent calendar to extinguish them. Mm-hmm. And whether that's because of multiple postponements, in which case Victor would need to tell them that if they continue to postpone, it's in danger of this, yada, yada, yada. But in essence, we're just creating a file of bad cases or unviable cases.
So so based on that, what's two things? What's a credible postponement? 5 business days? Less or?
We currently request 5 business days notice.
Okay, so you get 1 5 business day postponement or 2. Let's set the language and to say after that you go to the extinguished list.
Well, it's not a matter of that. It's a matter of they already have a case that's going to be agendized or already is agendized.
Right.
And then 5 days or 2 days or 1 day or 30 minutes before the meeting, they say they want it postponed to the next meeting.
Okay, do we give them 1 chance to postpone?
They get 1 free.
They get 1 free.
Yes.
Is what we're saying.
It's in our bylaws or complaint.
Oh, is it? Okay.
Yeah, I thought so. Okay,
I wasn't aware of that.
If we receive
That
one
rule.
request 5 days before the meeting, it's automatically granted. However, anything later than 5 days must be
less than
approved by
5.
the task force or the committee.
Less than 5 days.
Well, it
Yes.
sounds like that
That's
that
already
there's
in there.
enough controls in already existing, right?
Yeah, I thought we
So-
covered
Okay.
this somewhere.
But,
So I wasn't sure if it
how,
was.
how does that issue get
Administered.
canceled, administered? If it's in this consent calendar thing,
Well, then the last thing we
then
could
at
add is.
least there's a record of it being handled.
So what you can say is have that language and then say, failing that, it goes into that list and then gets voted on in the consent calendar.
Just it'll be dispensed with by the task force as to its.
And in talking about this, regarding our recent conversation about these requests for postponements to undetermined time, I would like to say that
they're not postponements
or continuances.
These are the continuance.
That's another item. That's a separate.
Yeah.
But we could maybe capture that language in it. Indefinite, like postponing indefinitely, which just keeps it on our calendar.
No, but under Robert's rules, postpone indefinitely means it's dead. It never comes up.
I would just say we don't accept indefinite postponements.
Right.
Done. Okay.
And it'll be scheduled for the next meeting or at the discretion of the chair.
Right. Okay. That sounds fine. All right.
And that's it's not documented, but it could be our practice.
Do you want this memorialized?
Yes, I would.
Okay. So let's memorialize it. Do we have
Okay,
quorum here? Yes, we have.
I will propose write something up regarding this issue and bring it back to you at the next meeting.
Okay, great. All right, let's hold off on any more of these. Look at them over the next month. Think of which ones you want to bring up at the next meeting, and then we'll continue on with honing our rules and tweaking them. All right, let's call the next item.
Next on the agenda, item number 12, Sunshine Ordinance Task Force Chair's Report. We did decide to postpone the update regarding the history of adoption of administrative codes 67.3. The next point would be public concern regarding the collection of public information to use for immigration issues or ethnicity targeting.
So I've been kind of not formally, but informally at various events or been stopped in the hallway here by various, mostly supervisor staff that were concerned about records requests that might include people who are now vulnerable to possible I don't want to. Yeah, I would say actions that are now apparent and in operation, which could include immigration issues and whatnot. So, or other legal issues. So, they're concerned about redaction. Like, how can they redact? Can they not redact? I mean, They are all very interested in making sure that they comply with the Sunshine Ordinance, but they're very nervous that they're going to lose advocates, civic participation, people bringing them complaints, things like that. I think the school board might also be dealing with such a thing because there's a large population of parents that are undocumented. Things like that. So I wanted to bring this up to kind of discuss it. And while DCA Cole is still here, I don't know whether his office has been talking about this anyway. I know it's a big subject with the Board of Supervisors at this point, but I don't know in this specific respect whether it's been discussed or not. So I wanted to just, again, I'll waive Robert's rules. Let's just have an open discussion about it and see what comes up.
Were there any particular data sets or examples that were mentioned in these conversations?
No, they were just saying that they were very concerned that people were that there may be like some dragnet or some groups that are targeting San Francisco that might, try to, because we're sanctuary city, they might start requesting from all kinds of departments, but they were just concerned about themselves. So there wasn't any specific example.
But do we get a sense of whether we're talking about the data itself or the metadata? Because
they wanted the names of the people that might be affected to read. They were concerned, they wanted to know if they could redact them.
Okay, so
those
redacting
names.
the names, we're not dealing with like identifying IPs that they were coming from in that side of things.
I don't know that they're that tech savvy enough to ask that question, or that they were even thinking of that. And I'm sure if you would bring up that point, they would probably say, "Oh yeah, that would be a backdoor way of finding out who they are." But
Because I mean, it seems like if we're dealing with, records requests being traceable to vulnerable populations, the city instituting something like Secure Drop for records requests as a channel to file records requests is probably one of the. Well, but you have to respond somehow.
But we also have an issue with city staff using software that would lose tracking.
Well, no, this would allow you to make the request pseudo-anonymously, but unfortunately it'd be actually anonymously, so they couldn't respond back to it.
Yeah, so these are like could be nefarious people trying to track down.
Oh, so we're worried about sketchy folks getting our data, not our vulnerable people being able to utilize the public record.
I think we're the situation. Just to throw out an example, is Alex Jones states to his supporters, file records request with the city of San Francisco for all emails that have the phrase "I am a dreamer" or "I am a undocumented immigrant" or "I am a," any, or just data sets where there might be a checkbox that, or people who participated in a public forum on some of these issues. What's that?
DACA.
Right. Or yeah. So there's a lot of things that would come up. The question is whether, this is difficult because I don't know how, the Sunshine Task Force comes up with a way to say that, oh yeah, you can just stop giving out public records. It's more like if they want to come to us, if they want to withhold it, then they come to us and they make the privacy argument under CPRA that this is the privacy of the individual outweighs the public interest in having this stuff out there, and then we just have to make a decision on that. That's what it sounds like it would be to me.
Yeah, but the point is how do we do? I think the big question is they're concerned that this could be a weak spot. This could be a vulnerable point because we are dedicated to transparency. That even if we determine a quasi-judicial, not even real judicial, but quasi-judicial, if we make the decision that it's in the best interest of the public to not release it, okay, that could be challenged, right? So then the question is there any way that we could affect something for this respect and it be kosher, for sake of a better word, and not challengeable.
So the issue,
it's a kind of a legal issue. So,
but I think that one of the pieces we're missing is that yes, it's what Member Moss brought up, and that might be specifically what we're focused on right now. But these other issues that aren't necessarily the names of people in the data, but how the data is requested and tracking the IP addresses of people that request data and all this stuff is all part of the same sanctuary city thing. And it seems to me that we are not very well equipped to build a solution for this. This is one element of this entire sanctuary city federal disconnect problem. And whatever we look at for a solution should probably be inside of the scope of that, because I'm assuming that the city's doing something about that and not just handing it to the Sunshine Task Force.
Well, then you're saying that the CPRA needs to be amended, because otherwise we would have to comply with the CPRA, or somebody would have to they would have to bring some kind of evidence that this should be withheld because it's to the best interest of the public, which is subjective. I mean, unless there's some legal standing that it should be withheld outside of a police investigation or HIPAA information or something like that. I mean, personal.
Become a sanctuary state, the CPRA would amend itself.
Right. That's right. So, I mean, it's a watch item, but I wanted to bring it up because people are starting to ask me about it because they think that they're like, where are these people going to be vulnerable? Can I give this, if somebody requests this information and they know for a fact that somebody is targeting somebody or doing a sweep of information, I mean, it could end up being in public data.
Well, I mean, there's absolutely nothing prohibiting someone who gets a request for data that they feel puts someone. This may or may not actually be a good idea, but let me just say that there's nothing preventing them from letting the person know that this document about them has been requested. Of course, that in itself creates a document of that contact. So.
Okay, so I think one thing, I just wanted to bring it to your attention. I wanted to bring it to DC Ecola's attention and to Victor to transmit to the clerk's office, because I think this is an issue that is going to have some discussion at the policy level. So DC Ecola, if you have any information coming out of the city attorney's office, that would be helpful as advice for us on it. And the same thing from the Board of Supervisors, if they're going to be dealing with that, or any information regarding what the state is doing with regards to sanctuary state status, so we can keep abreast of this as real time, because we're going to have, if these situations come up, we start getting complaints. We want to be able to act accordingly and timely with the most timely information. So,
yeah, I should add that there's a lot of legislation that's in flux right now that would have huge impacts on this.
Right. So I think, I'm sure you will, Member Moss, in your role at AFF will.
Yeah, they've dropped like 3,000 bills in the last week, so we're working through them.
Yeah. Okay. All right. And that's all I have for right now. Thanks. Next item.
Next on the agenda, item number 13, report from the Compliance Amendments Committee.
So if it's okay with Chair Kanata?
Please.
All right. So a couple of months back, we had some visitors from the Department of Technology to go over two issues that we've been trying to look at for some time. I'm going to go ahead and start with the issue of out-of-office email. And Member Kanata can help me out with this. It was a while back, so I will listen to the tape again. But the basic answer when we were asking questions about out of office was ask Microsoft. That is what we were told on a regular basis, was ask Microsoft. So the city email is hosted on the cloud by Office 365. And that in itself as a system is managed by the Department of Technology. But the Department of Technology does not control email at the department level. That said, ever since we started asking about this, that prompted the Department of Technology's PIO to bring this issue to some apparent club of public information officers within the city to start talking about whether there is some sort of uniform policy they can have for out of office, and maybe in general how they should be responding to public records requests, period, whether that's having a sunshine email box or figuring out best practices for how to put in your autoresponder, who to contact if this is a public records request. I have not heard back from them about the status of this, and that's something I need to check on, whether they've actually got a draft policy together. We started asking them questions about whether they could set up filters that look for the words immediate disclosure request and then automatically forward those someplace. They kept saying that is an unreliable way of doing things. I don't think they fully understood that the law actually does require an IDR to have that language in there, so you can reliably deal with that with an IDR. So maybe they thought a little more.
Should we have EOT send a memo?
Possibly.
Or you guys send a memo to...
Possibly. So I want to hear what they say more, but we can certainly talk to them more about it. What we did learn that to solve our problem of repeatedly having complainants say that they did not get an out-of-office email and there being no record of said out-of-office email existing, we can request a log from the Department of Technology about whether an autoresponder was turned on or not. So next time we get a complaint where somebody says they filed an IDR and they did not get a response, and the agency says, but we had an autoresponder that told you who to contact, the committee who is hearing that should immediately ask the Department of Technology for a log, because that will be the only piece of evidence showing whether an autoresponder was on or not. And that has to be done. They gave me, I was listening to the tape. At one point they said 90 days. At another point they said 180 days.
Yeah. It was vague.
What's that?
It was vague,
It was
the number
vague.
of days.
So, yeah. But it does seem like they're thinking about it. But, yeah, there is no copy of OOO emails. Member Kanata had suggested several workarounds.
Yeah, my big question to them was, if I send an email in, and I get back the response that say I'm out of the office, please contact so and so. My question was, why can't my email be automatically routed to so and so, to whoever they're telling me to contact? I think that's doable, but they wouldn't. The person up there wouldn't step up to that. His answer was, There is no department-wide policy. They're working on it. And the answer he came up with, his best answer, was that every department should just have a Sunshine mailbox that somebody would be checking all the time.
Right. And we pointed out that that would not work exactly, because even if you have a Sunshine box, everybody who works for the city of San Francisco has to be able to respond to a public records request. So I'm not necessarily sure what the next steps are with this.
I will tell you that I think we should drag him into a training. And so I attend the COIT meetings, which is the Committee on IT, which is all the department heads and all the tech heads from each of those departments. I think I could they just hired a new CTO at Department of Technology. I think it's time.
Okay.
They've been needing it for a long time. And you should know there's a very famous case here, Wooding versus the Rec and Park Department, where we had adjudicated and found a violation, ordered a backup of email to be uncompressed, unarchived, and presented to show evidence that there was what showed the violation. It was the first time that that ever happened in city history. So we know that there's backups for everything. We know they're centralizing stuff. So they just need an order from somebody to do it.
Yeah.
They won't administer, but if somebody tells them to do something, they will track it down and do it.
Yeah, the overarching problem, though, is that Office 365 does not archive your auto-responding emails going out.
Right.
And there's not going to be a way around that, apparently, unless we ask Microsoft. So as far as our evidentiary problem, the log is where we're at right now.
We can ask, make a demand or a request, a strong request, and I could ask the Board of Supervisors to do it on our behalf, to create an ordinance requiring that auto response messages be recorded in some way or captured in some way. And they have this huge contract with Microsoft. I'm sure that they will, jimmy rig some code to make it happen.
Yeah.
How does it not register a sent mail that goes through the MX? Like, even if it's Office 365, it's still using the MX channel, so it's still sending the mail.
But
I've got 2 words for you. Ask Microsoft.
Right.
That's all I have.
It's it's just sending it out blindly. It's not recording. It's not saving it anywhere. It just sends it out on the fly.
I mean, I understand what we're talking about, but I don't understand how they would have intentionally built it that way.
Yeah. I know in my system I use Zimbra, and the outgoing, it's not captured, but on the receiving end, people get it. So, I mean, the only thing you could do is force it to carbon copy to itself.
That was another suggestion that Member Kanata had, was that somehow when you're out of office, that perhaps and they seem to think that this was doable to configure it that your autoresponder is always CCing somebody else. But the question is then, even if we figure out something that would work, how do we get a department, a citywide guidelines in place?
That's what we create an ordinance.
Yes, we create an ordinance. There we go.
So think about doing that if you think it's feasible.
All right. Well, I will put that up to our chair of the Compliance and Amendment Committee to figure out how to handle that on our agendas. So if there's any other questions on that, I can answer that. Otherwise, I'll move on to the second issue, which is SB 272. I'm going to be mostly reiterating what our presentation we received. What I would actually say before that is that my version of it is not going to be as great as the Chief Data Officer's version of it, and so I would suggest that she could do an encore performance for the task force, because it was very clear, very succinct, and really informative about how that department works and their efforts on data in general. But the basic is that SB 272 is a new law, and it's part of the Public Records Act that is kind of complicated and kind of vague, but to simplify it, it requires every local government agency to compile an inventory of what are called enterprise systems. And for the purposes of the law, the enterprise system is described as either it has to be two things. And on the first thing, it has to be either a interdepartmental system of records, or it has to have information on the public, and then it has to be a system of records, which is not particularly well defined, and it'll probably come on to us at some point to interpret what those words mean. But the way that I like to think about it is we are looking at, they need to create a inventory of the software that they use to store information and what that information is. And for each one, they need to say what department it is, what the system does, what kind of data it holds, who the vendor is. It's like a whole tier level of things. Now, the thing that's interesting is that the city of San Francisco, as this law was being passed, had already been complying with an ordinance that required them to create an inventory of all the databases that they have, which is slightly different than the law is phrased, but there was significant amount of overlap that when the law passed, the Data SF just volunteered to compile this new SB 272 inventory because they already were 3 steps ahead taking this database. And so they were able to come into compliance, and they have this ginormous data set on open data. I think it's datasf.org or datasf.gov that has all of the enterprise systems that the city of San Francisco has. There are some complications that we're probably going to face if we start getting complaints on this. The first is it's unclear who a complaint would need to be filed against, because the CPRA just says like the agency, which would be the city of San Francisco. But then the question is, if the assessor's office failed to report something, who do you file that complaint with? Do you file that complaint with the Department of Technology and Open Data? Do you file it with the individual agency? There is no clear identification of who is the responsible party. Let
me interrupt you for a second. But since the CPRA falls under our purview, and also the supervisor of records, okay, there are 2 open areas, and the ethics, partially the Ethics Commission, but not really. But I would say that's where I think it's going to get addressed.
Well, I mean, yeah, it's just a question of when somebody files a complaint and who they file it against and whether that's the right party or not. We'll have to figure out whether the right party is, because if the database is incomplete, is that Data SF's problem, or is it the individual department that failed to give it properly to Data SF? And something that we'll probably have to sort out at some point. I'm just trying to identify issues that are unclear with the law that we'll probably have to set some sort of precedent.
So let me ask DCA Cola, is your office working on this at all? On how how the city is going to comply with this new law? You know?
If someone is working on it in my office, it's not to my knowledge. I don't know.
Okay.
No. But I mean, if it becomes state law, it'll.
Oh, it is state law. It is state law now.
Yeah, it's
just these little points that Member Moss is bringing up, like if there's a complaint, who does the complaint be brought against, and what venue is to be used to file a complaint?
You know, this is the sort of thing that's going to fall on the other side of the ethical wall from what I do.
Right.
I would assume it's probably with someone on a government team in my office, probably Paul Zarefsky.
Okay.
I can inquire through the channels that I'm allowed to and see what's going on with it, but I'm not aware of anyone that's working on these issues right now in my office.
If you can just inquire if somebody is working on it, we can carve out some time to have them come and give us a report.
Sure.
How about that?
Great.
Thank you.
And so another element is that this inventory needs to be available in like a paper copy for inspection. I asked who has that, and the chief data officer said, well, in practice, we have it, so people can come to us for it, but there's nothing in there's been no formal designation that says that they are the custodians of this particular document. What Data SF is doing is going department by department and with their version of best practices for how to fill out the disclosures to hand to them, and they're giving people examples of what good language looks like and what it doesn't look like, and they're trying to work people through, and we gave them some advice that I guess they're going to be incorporating into the next version. But again, they're kind of just doing it on the fly, and they're doing it voluntarily, not as if somebody had particularly assigned them to do it. One of the problems that I identified that hopefully they will address is that the law requires for each enterprise system the agency needs to disclose the purpose of the system and the types of data that's collected. And currently, while most cities and counties have that as two separate fields, those are jammed into a single field in our database inventory. So when it should say, like, there should be two different descriptions, instead there's only one blank, and oftentimes it'll be like the word orthopedics, which doesn't tell you what the system is for or what kind of data is in there. It just has a word, and that is a constant problem. And I mentioned to them that to be fully compliant, they should be split that into two categories, and those actually should have descriptions. And again, Data SF doesn't necessarily have the authority to go around like strong-arming people to come into compliance, but
it sounds like we should have Jay Nath come in next meeting, give us an update on this.
Who's Jay Nath again?
He's the mayor's Office of Innovation, which handles all the open data.
So the chief data officer, Joy Bonaguro, is who spoke to us, and she's who I would recommend for just an overall presentation.
Okay.
So
spell her name.
I think it's Bonaguro. I think I grabbed that.
First name again?
Joy.
Joy. Okay.
Yeah, it was a really good presentation. I got a copy of it.
She's at Department of Technology?
Yeah, she's the chief data officer for Data SF.
Okay.
Yeah, she'd explain. I mean, if we had her here right now, she'd be explaining this much more quickly than I am.
All right, I'll give her a call because she's got to give it to us in kind of a dumbed down version so everybody can.
She had slides with like illustrations and arrows and everything.
I know, but if you ever looked at a data schema before that's really huge, not understandable to most people.
She's better explaining it than I am.
Okay,
let's just put it that way.
Okay, good.
So there's definitely, I mean, some of this stuff we're just gonna have to deal with as if complaints come in, and but anyhow, that's what I've got from the meeting.
Great. Anything else to add?
No, just that the presentation I could understand it, so it was real easy.
Okay, great. Then sounds like a good person to bring. Okay. Anything else for the Compliance and Amendments Committee members? Any questions for them at all? Nothing? Okay, great. Next item.
I'd just like to note there's no members of the public in the room.
Yes.
Next on the agenda is item number 14, Administrative Support, Complaints, and Communications. listed on, I wanted to remind all members of the task force that the statement of economic interest is due by April 3rd, 2017. I did send an email to all members with the link to the online form, as well as the Sunshine Declaration and the Ethics Training Declaration if needed. Those are all due by April the 3rd of next month. Next is the tentative schedule for the committees and task force. I believe that, Member Kanata, what day were you unable to attend?
The second Monday in May.
I assume we'll work on getting a replacement for that meeting as we get closer to it. Next is regarding the complaints submitted this month. As you can see, there's 2 of them that I have not yet processed.
Add me to that list, May 8th, I'm out as well.
You're unable for May 8th. Regarding complaints submitted over the last month, you'll notice that there are 2 of them that I have not processed, as they don't appear to be sunshine complaints. They appear to be complaints against judges at the Superior Court level. However, he submitted to us on a complaint form, so I sent him communications asking him for clarification, and he probably will not give it to me because I did speak with him, and he's not coherent.
Okay.
Next on the agenda,
If you need me to intervene, let me know.
We can't process. He didn't give us enough information. So
Okay, very good. Thanks.
Next is item 4, pending complaints. We do currently have 19 pending complaints, which is a reduction from last month. Next item, pending complaints
How many total pending complaints are there?
19 total, minus what we've heard today.
Okay, great. Thank you.
There are 3 complaints pending before the Compliance and Amendments Committee. Those are scheduled for the meeting on the 13th of this month. There is 1 pending before EOTC. I did send a communication to Mr. Peel regarding this matter. He has not responded to me. We're trying to convert that to a hearing. As he has not responded, I will work with Chair Joss Wolf, and maybe we can just schedule this and deal with it. There were 2 other ones that were the same situation, and Mr. Planthood agreed to convert them to hearings, and that has been done. That's why they have been removed from this list. Next, communications. I'd just like to inform the task force that this coming Monday, we will be, Chair Wolf and myself will be meeting with members of a delegation from Japan to talk about the Sunshine Ordinance and questions that they have about it. That's going to be this Monday, March the 6th at 9 a.m. We're scheduled to meet in room 270.
They're from the Chiba Prefecture.
There is a request for training from the Department of Building Inspection Code Advisory Committee. We do occasionally get requests for training from various departments, and I believe there may be a request for the EOTC.
I'm punting it to EOTC.
To maybe develop a training that we can
take on the road. You hear that, Member Josh Wolf? Okay.
And then again, just another reminder regarding the deadline for the Statement of Economic Interest.
Okay.
That completes my report.
Any questions for Victor? Okay, next item.
Next item is item 15, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay.
I had a quick...
Member Moss first.
Sorry.
So at 10 a.m. tomorrow, the California Supreme Court is finally ruling in Smith v. City of San Jose.
Oh.
This is the huge case over whether government records that are stored on private devices or private email are subject to the California Public Records Act. What comes down tomorrow will have a huge impact on records across the state, including in the county of San Francisco. I would ask the chair that perhaps maybe DCA Cola could report back on that at the next meeting, because What's that? Sorry.
Can you give us a quick preview of the range of potential?
Microphone.
What you would.
I am not a lawyer, so
What are others
the worst case scenario? Well, I shouldn't put it in terms of worst or best case scenario because this is just sort of my personal thing. But on one end of the spectrum, the Supreme Court could come back saying that records on private devices, no matter how they involve the public business, are not public records, and that would allow government agencies to start communicating secretly on their phones and through Gmail accounts, and we would never know what happens. The other end of the spectrum is that they could say, no, anything that involves the public business, no matter what device you communicate on, no matter what email system you communicate on, it's a public record. The complication then becomes, well, if you put in a public records request, are you therefore authorizing the city attorney's office to start searching people's phones whenever somebody puts in something? That's not necessarily unnavigable, but it is complicated.
Is it retroactive?
That I don't know. So that is beyond. I assume it would affect from when the case was filed, moving forward. But I'm not a lawyer, so.
Well, you make a public records request of something that happened 10 years ago.
That is a good question. So, I mean, I assume that retention policies would have to be written. Then the various cities and counties would have to write policies saying do not communicate on these devices, or come up with procedures where you tell people that if we tell you a public record request and it is your responsibility to search through your own devices, and if you do not turn over stuff, then you're the one who's liable for violating the Public Records Act. I don't know. We will see tomorrow. This has been a long overdue decision. Right. So I'm very excited. And 10 a.m., that's when it's supposed to come out. So they were very specific.
Okay. Is it televised?
No, so they've already had the hearings. This is them issuing the opinion.
Oh, okay.
So the opinion is out tomorrow.
Where can we find it?
On the California Appellate website.
Okay.
The only other thing I would mention is that there's a lot of legislation coming up that has already been introduced that would affect the California Public Records Act. Some of which include things ranging from all police policies need to be posted online to the Department of Consumer Affairs licenses can't be public anymore if they include people's personal details. It's like a weird range of things, and hopefully I'll have time to sort through them over the next couple of weeks, and I can identify certain things that maybe we should look at the next meeting.
Okay. Great, thank you. I have one announcement, just that I'm in communication with New American Media again, trying to figure out what to do about our vacant seat that we're having difficulties on kind of processing because it's got to come from that particular organization. So they're in touch with, possibly get some help from some other organizations to get a viable candidate to nominate. And so we'll try to get a full 11 members. And I also want to extend to the clerk that she can appoint somebody to sit ex officio. And I will send a memo to the mayor's office because there's also an ex officio seat for the mayor. In 1 year, we did have a fellow by the name of Shepard Smith. I can't remember his name. He was the father of the attorney that represented Ross McCarimi in front of ethics. But he sat on with us, and it was very helpful, actually. No, not David Wagner. No, his name was Shepard. I think his last name was Shepard. But anyway, he was very helpful. I mean, he was very circumspect. He had very interesting perspectives and provided us with some good food for thought. I felt at the time. So we'll seek interest from them again. They can't then say they didn't know about something if they're here, and they can report back. Actually, you can, yeah. We get them in here, drag them in from another room or something. All right, anything else for the good of the cause? Yes.
One last thing.
Sure.
On the, when we look at the items on that first page, Victor, you kind of have that sort of checklist, petition, complaint, memorandum, et cetera. Could you add another column there with date? Just be nice to track, when the petition first came in.
Oh, yes.
Memorandum, if that's not too much of a
Are you
burden.
talking about my list of incoming complaints?
No, the first page of an item, when you put the file number.
Oh,
item
you're
number
talking
4.
about my checklist.
Yeah, your checklist.
On the checklist, you want to have a date of...
Date column, just date column. So for instance,
regarding-
petition complaint, March 1st. Memorandum from Deputy Attorney, March 2nd. Supporting documents received, response, just a timeline. Order termination.
Sometimes there are multiple submissions.
When you can.
No, there's multiple submissions from the various parties.
Okay, but the important ones would be like the actual petition and complaint when that first came in. The order determination, that would be an important one, et cetera. I mean, I don't know. It would just be nice to have a sort of a...
I will develop something and see what, if I can give you additional information.
It doesn't have to be the whole thing, but it just kind of...
Certain items which would be helpful.
Yeah. Thank you. The fact that you got the pages listed there is great, but it'd be nice to kind of see a timeline of when pieces came in. They come in time for the meeting, whatnot. That's all.
Is that it? Okay, motion to adjourn.
So moved.
Second.
All those in favor? Say aye. Opposed? We are adjourned.
It's not 9 o'clock.
Adjourned.
It's not 9